Chief Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Welcome to the second day of our three-day session. Glad to be live again after a year and a half. Sorry for the necessary precautions, but we certainly want to keep everybody safe and still be able to argue in this fashion. Brian, will you call the first case? For the audience, I have a note that there is no relation between our counsel. This is a matter of first impression concerning the standards the trial court should apply in assessing proper venue in cases involving an internet-based defamation cause of action. Ms. Heim.
Good morning. If it pleases the court, my name is Angela Heim. I'm with the law firm of Rollin Henderson, and I represent an appellant in this action, Stacey Smith. And I am joined by other attorneys representing other defendants in this appeal. My colleague Pam Dorian, who is involved, may have some things to say at the end of my arguments. So we'll see how that goes. Right before I get started, just in full disclosure, it's even a little more ironic because my husband's name is actually David Heim. So when I saw his entry of appearance, it was a little disconcerting. Just to get started, this appeal involves a purely procedural question of law. Did plaintiff file this defamation action in a proper venue? Defamation laws as they apply to internet-based claims are still formative. It's hard for the public, let alone the courts, to keep up with all of the internet-based media forms of communication. Keeps growing every day. There seems to be new ones popping up that I'm hearing about from my children every single day. So it's hard to keep up. It will continue to evolve. And even the most established legal boundaries can be blurred or can even become unworkable or can effectively marginalize the actual purpose of the laws themselves. And on top of that, with laptops and smartphones, anything on the internet is basically available anywhere. So it's not limited in the ways that it used to be. The purpose of the venue rules, as stated by this court 60 years ago, in County Construction versus Living Good Construction, is to permit a plaintiff to initiate suit against the defendant in a county most convenient for him or her and the witnesses, and to assure that the county selected has a substantial relationship to the parties. And as pointed out by the appellee at page 9 of their brief, a venue that is substantially connected to the dispute. Each of the venue rules in this Commonwealth protect this purpose and frame these limitations. On the other hand, the most important function of an action for defamation is to give the plaintiff a public vindication of her good name, to restore an unjustly tarnished reputation, which has been defined as the estimation in which one's character is held by his or her neighbors and associates. This was set out in the restatement of Tort Section 577 and adopted by this court in Gaetano versus Sharon Herald Company. And those are very specific words to use to describe the purpose of defamation laws. neighbors and associates. Neighbors certainly conveys where you live, and associates certainly conveys where you work. And that is what we're saying here today. That this court in Gaetano is discussing this purpose within the framework of the facts of the case. And publication involves third-party neighbors or associates reading it and understanding it to refer to the plaintiff. So where the plaintiff lives and works or has some other significant connection. Now, I am sure you're familiar from reading the briefs with Gaetano. It was decided over 50 years ago. There haven't been many cases that really have discussed it since. It was a newspaper case. And incidentally, the court stated in the very beginning of that very, very short opinion that it was recognizing that venue rules can become unworkable in many situations, and especially involving, ironically, our present media of communications. And in that case, the defendants were arguing, and it was a rule that had been applied, is that the place of publication for defamation was really where it was printed, where the defamatory content was printed. And the court had a concern with that because in the present day of communications back then, newspapers could now be sent to different places, people could subscribe from counties and counties away, and the court was concerned with limiting a plaintiff who was defamed through a newspaper to suing the newspaper company in the form in which the newspaper was printed, because it could be a whole state away. So they crafted a rule for venue in defamation that took various factors into consideration. And one of the things, and by adopting the neighbors and associates language from the Restatement of Torts, section 577, they reiterated that the venue statute, yes.
Sorry, I'm not good with that button. The Superior Court opinion notes that you concede and parties stipulate, I'm not sure it's a formal stipulation, but agree that if Gaetano as written applies, then venue is proper. Do you recall that statement in the Superior Court
recall
opinion?
that statement in the Superior
Do you
Court
disagree with
opinion,
it?
but I disagree that
Okay.
we made any kind of concession like that. And from our briefs, we didn't. I mean,
So you're asking that we change the law from the Gaetano standard? Or are you arguing that under the Gaetano standard, that venue doesn't belong in Philadelphia?
I'm arguing that the Gaetano standard is a workable standard in certain circumstances, but it has to evolve. So I'm not asking that it be changed, but I'm asking that the language in
Subtle
Gaetano.
distinction between evolve and change, I suppose.
Yes,
Go ahead
very
and answer.
subtle. But what we're saying is that a certain sentence or two out of Gaetano, I mean, they did say at one point, admittedly, that no cause of action for defamation can arise without a publication. And they go on to explain that. But that particular language can't be reviewed in a vacuum. It has to be reviewed under the facts of that case. And the Supreme Court discussed, once again, it was a very short opinion, but several times they discussed a plaintiff's neighbor and associates. They discussed giving the plaintiff a right to redress in his own bailiwick. So,
Counsel, I apologize. While you're on the subject, you remind me to ask you this question. In your brief on page 11, you specifically say the judge New from Philadelphia failed to heed the court's acknowledgement in Gaetano that a plaintiff's residence is fundamental to determining where venue in an action of defamation arises. And you cite Gaetano at page 755. Can you share with me at 755 in Gaetano where it indicates residence is fundamental? Because I read it and I failed to see it.
I think it is at least implicit, if not explicit, by the court's discussion of neighbor and associates.
I apologize. When you say it's fundamental, that doesn't mean implicit. That means it is essential. So when I'm reading your brief, and I'm taking your brief as true from your position, that residence is fundamental to the determination in this action, and you cite Gaetano, but I'm asking you to directly refer me to that section of Gaetano that reflects that venue is fundamental, because that's the crux of your case, that it shouldn't be in Philadelphia because the venue of everyone and those who allegedly read this article are from Delco, so it shouldn't be in Philly. So venue is, residence is at issue. But the way I read Gaetano, residence is not fundamental, so I want to correct my misunderstanding by you telling me where it is.
Those precise words are not in Gaetano, that residence is fundamental, but like I said, it is a very brief opinion. The plaintiff was from Allegheny County in there, so it wasn't really a discussion about where the plaintiff resided per se.
But it's the opposite. It's the opposite of what you're maintaining. Gaetano made clear it's where it's read. It was read in Allegheny County, and that's why venue properly lay in Allegheny County, not in Mercer County. So when you answer Chief Justice Baer and Justice Dougherty, I'm not sure you were entirely forthcoming, because you're not comfortable with Gaetano. You don't want Gaetano to apply in the internet context, it seems to me. So my question for you is, having availed yourself of that medium for communication, why doesn't Gaetano mandate that the reputation, that venue lies where the reputation is harmed by the reading of your publication? Isn't it as straightforward as the Superior Court said it was?
Well, I don't believe it is, because in Gaetano, as I said, the plaintiff resided in Allegheny County. So the harm to the plaintiff's reputation was suffered in Allegheny County. It can't just be looked at in the context of where it's read. The whole opinion was guided by the fact that the plaintiff resided in Allegheny County. The court referred to the neighbors and associates, referred to a plaintiff filing in his or her own bailiwick. The whole opinion was crafted around the fact that the plaintiffs resided in Allegheny County.
But we're
coupled
here
with
on
the fact-
preliminary objections, therefore plaintiff gets, we don't know what happened here, but we know the plaintiff gets the truth of all the averments of the complaint and all the inferences therefrom, and under the complaint and the inferences therefrom, the plaintiff here was injured in Philadelphia. And as I think Justice Wecht alluded to you can't be surprised by that. You put it on the web. What'd you think was going to happen? You took billboards out and said, read our website. So this injury could have been in Africa. If somebody there knew what are the elements of Gaetano, knew the plaintiff, knew that the statements were false, which again, for preliminary objection purposes, we have to accept, knew that and recognized that the plaintiff's reputation was damaged. And so this is Gaetano. Wasn't the newspaper published in New York City and read in Pennsylvania?
That was an example given in Gaetano.
Okay, yeah. So all I'm saying is that, as Justice Wecht alluded to you, what do you think was going to happen when you put this on the web and took out billboards and notices and posters and handouts and said, read our website?
Well, respectfully, it was a little more locally confined. The billboard that was all in Delaware County. The mailings were in Delaware County. Venue for that purpose is not here.
And it's changed the facts, changed the result. You could have used direct mail. We've all been engaged in statewide campaigns. You could have used posters. You could have used local signs or whatnot. You put it on the web.
Right, but all of the conduct occurred in Delaware County. There's no dispute as to that. Everything was done in Delaware County.
Opposing counsel disputes that. We're here on defamation. Let's step outside your facts. Let's assume the facts of this case and the background of the election, it's all red herring. The issue before us is defamation. Defamation occurs when published, and the publication results in an associate or neighbor or friend knowing the information to be false. So we're looking through a myopic blinder. Friend in Philadelphia opens the internet, reads something, published, read, understood to be false. Tell me how Delaware County has any play with the close binders of the venue rules. Occurrence equals venue, occurrence equals publishing, Publishing equals Philadelphia, therefore Philadelphia equals venue. How is that wrong?
Well, Your Honor, it's a very slippery slope, and it
No,
opens up the door.
I think it's, restatement says it, our case law says it. I'm asking you, tell me how we're going to climb up that slope to make it to make Delaware County the place of venue.
Well, it goes back to the language of the restatement and the language of Gaetano, which once again focuses on neighbors and associates, which has more to do with where you live and where you work. It wasn't anticipating somebody far removed from that in several counties over.
But when one places something on the internet, which is not locally or county restricted, one is quite aware that it can be read anywhere. And it's almost like a author beware. If you want to put something false on the internet, be prepared to be sued wherever the damage occurs. That's how I'm looking at this. Share with me why, with this current technology, I'm wrong.
Well, because venue rules are intended to create some geographical limitations, and a rule that just says wherever somebody reads something and knows the plaintiff, that becomes way too broad and basically obliterates any geographical limitations there are.
Or as the Chief Justice Behr said, use local postcards, direct mail in a public election. Why publicize something on the internet when it can be read in Philadelphia, Chester, and Bucks, when you're looking specifically for Delco? I don't understand your argument, because I want to put it on the internet for the world to see. I want the benefit of the doubt of saying, because I live in Delco, it should be in Delco, but the harm, which is the definition, the publication, the definition of defamation, happened in Philadelphia.
You know, it's an old cliche, but you can't kill your parents and argue to the court you're an orphan. You put it on the web, and now you got sued where it was read.
It was put on the web, but I'm still just going to go back to the fact that Gaetano refers to neighbors and associates. They didn't use words like friends or family or acquaintances or anything of that sort. They picked very specific words, neighbors and associates, which refer to, respectfully, where you live and where you work. So they weren't anticipating venue that could be anywhere. They anticipated limited venues for things where your harm, because a plaintiff suffers the reputational harm themselves, and they suffer it where they live or where they work. And there might be some other venue that's appropriate, but this is just, in an internet-based case, it just goes too far to say it's wherever it was read.
Ms. Heim, is part of your theory that I don't want to call it harm, but the impact that was intended by the post was intended for Delaware County because it was about a Delaware County political event, political race, so that the harm being not winning the election was centered on Delaware County, and that somehow centers your focus of the harm as limiting it to Delaware County? Is that part of your theory?
Yes, in part, because if you look at the complaint, that's what's discussed. All of the harm, for the most part, that is discussed deals with Delaware County. The plaintiff goes into detail about all of her connections with Delaware County, all the different associations and organizations that she's involved with, all her jobs, and the fact that, this election, and what she alleges is that she lost this election. She lost potential clients. She lost this, that, and the other thing, and it's all focused in on Delaware County for the most part.
Counsel, the issue is not the election. The issue has nothing to do with Delaware County. The issue is the publication of a false statement, that being that she was wrongly convicted, correct?
Correct.
Therefore, the information of her being wrongly convicted was published, produced, and read in Philadelphia. What does the allegation or the misrepresentation of a criminal conviction, which harmed her reputation, what does that have to do with an election?
What has to do with that was part of her claim. I mean, it was the crux of her claim. That's why she filed her
Crux of
lawsuit.
Her claim is that it was, the information was misinformation that didn't even confirm her age with that of the alleged defendant. Has nothing to do. I see this election as a red herring. Facts just to prejudice the trier of fact. The issue is, what is the venue for defamation? What is the publication? So share with me. I'm really struggling to see your point of view, but I see no way, shape, or form under the law how this election has to do with the publication of a material misrepresentation of a conviction that was not hers.
The election was part of the plaintiff's claim, but in looking at the venue analysis and how the lower courts relied on Gaetano, they, in my opinion, cherry-picked a particular line or two out of Gaetano without applying all the facts. And the reason there was a publication in Allegheny County was not necessarily just because it was read there, it was because it was read by a neighbor or associate of the plaintiff, and it was because the plaintiff resided there. So the residence of the plaintiff in that case was instrumental in the outcome of the case. There's nothing to indicate in Gaetano that if the plaintiff hadn't resided there, that the outcome would have been the same. Because like I said, the court really focused on neighbors and associates and the plaintiff's own bailiwick. So respectfully, I think Gaetano, one or two lines have been looked at in a bubble without the application of the rest of the facts. And just as one example, and while it is, of course, not binding on this court at all, but it's very instructive, there was a Philadelphia County opinion in 1997 in Chestnut versus Hill School by Judge Heron there, and his opinion was affirmed by the Superior Court without opinion. That judge's interpretation of Gaetano dealt more with even the defendant's conduct in placing the newspapers in Allegheny County. And this judge said in Gaetano, the Pennsylvania Supreme Court held that venue was proper in Allegheny County because the defendant newspaper had published the statements there, that is, circulated the article to subscribers in Allegheny County. And that opinion focused on where a newspaper causes a particular newspaper to be, a newspaper company causes a particular newspaper to be sent to a particular district. So, there is certain cases, and there, like I said at the very beginning of my argument, there are very little cases that actually discuss the venue analysis in Gaetano. I mean, Gaetano, if you shepherdize it or something, it has been cited in like 55 cases in Pennsylvania, but not for venue. It's cited mostly for other reasons. So, I think courts have struggled with it. And the reason I suggest that there aren't more cases is because more often than not, the plaintiff does file the lawsuit in their county of residence. So it's not really an issue that pops up. But if it does, and it could, if this whole venue analysis is opened up like this in the way that the Superior Court did, with applying Gaetano without applying all the facts of Gaetano, that it really could open up venue to be anywhere, and it will essentially obliterate venue as a limitation in defamation cases, especially internet-based defamation cases. We could, that's a different analysis, and rightly so, that analysis takes into consideration and gives deference to the plaintiff's choice of forum, whereas whether a particular venue is proper or not doesn't take the plaintiff's choice of forum into consideration. It's not a factor. It's either venue is proper or it isn't proper.
Well, I think the forum nonconvenience option, though, diminishes the floodgate principle that you're espousing, that this opens it up to, venue anywhere.
Right. And I also think that,
Finished. I think we understand your argument. I don't think there's additional questions. Why don't you take a sentence or two if you need to and finish up?
right. Yeah, just to wrap up real quick, we think what we're proposing is in fact consistent with Gaetano and is consistent with the Reed case that is discussed in the briefs, but we didn't discuss here today. And ironically, Gaetano dealt more with where a plaintiff resides, and Reed dealt more with where a plaintiff works, or in that case, actually lost a job opportunity in the particular venue at issue. Because really it deals with where the plaintiff suffers the reputational harm, whether it's where he lives or where she lives or where she works. And that is what the venue framework in the context of defamation and internet-based defamation cases, that's what it's meant to do.
Thank you very much.
Thank you. And
I think we've beaten this dead horse, so
Fair enough, Your Honor.
1 minute.
Good morning, may it please the court. My name is Pam Dorian. I'm here on behalf of the appellants in appeal number 42, EAP 2019. I agree with Your Honor. I think I won't be repetitive here. I just want to briefly address 2 points that I think were brought up during questioning that I'd like to add on to. The first being I'll call it the buyer beware argument. What struck me, and I'm going to borrow this from an oral argument that actually the DC Circuit heard late last year, that this hearing as we speak is currently being live streamed on YouTube, as it was in that case. And it occurred to appellant counsel in that case, just as it occurs to me now, that there might be viewers certainly across this Commonwealth, maybe across the country. And setting aside judicial privilege and those associated privileges, suppose one of us were to defame, accidentally of course, a Pennsylvania resident, let's say a Dauphin County resident. Would we then be able to be brought into the forum wherever that was read or heard and understood, whether it's in Erie County, in Wyoming, in Alaska? I think
The answer to your question would be yes, if the person in Erie read it and knew the statement to be false.
And I think, Your Honor, the problem with that and with internet defamation cases generally is if that's where we're drawing the line, that, as Ms. Heim pointed out, I think the trial court, the Superior Court, at least in the concurrence, I think we're a little uncomfortable with the fact that that would essentially invite venue in any of the 67 counties in Pennsylvania.
Again, the case is distinguishable. You're not streaming it, we are.
Fair enough, Your Honor. I think the point remains that, venue is not supposed to be this fickle thing. It's supposed to be essentially an anchor that ties that forum to the cause of action. And I think the Doe case that we cite in our brief, it's in a defamation claim, it's where the sting of the defamation is felt. And I think our point here is that while the internet has certainly changed a lot about our lives, it hasn't changed where your community is. And in Gaetano, it was an easier case, I think, than this one. They all intersected in the same county. It was a newspaper sending copies to Allegheny County, where the plaintiff lived. And that's not this case. I think, to push back a little bit on the red herring characterization of the election, I think, respectfully, the entire complaint is very much centered on reputational injury in Delaware County. Of the 164 allegations, there are allegations of harm, again, to her reputation, to her career. And I specifically wanted to read paragraph 158, which I think really hits this home, that the allegations of damage were for her perceived fitness in, quote, any position of trust, including as the mayor of a small community or as a realtor. And the question here is, where is that small community? It's not in Philadelphia. Out of the 164 allegations in the complaints, we have what is essentially, I would submit, a throwaway sentence of, by the way, somebody read this and understood this in Philadelphia. That sort of de minimis harm can't be enough because, again, that would, establish, there would be no geographical limitations. And I think this would be a different case if she alleged that she lost a job or some sort of actual reputational harm in Philadelphia.
I think your argument substantially overlaps your co-counsel. Would you take
Understood,
a
Your
sentence
Honor.
and finish?
I would just, the last point I'll leave with this court, and I'll be curious to hear Mr. Heim's argument, is, where exactly in the complaint is there reputational harm alleged in Philadelphia, other than what the persuasive authority in our brief calls de minimis harm? Where was the sting of the defamation felt? So thank you for indulging me, Your Honor.
Well, can I just ask you, why isn't the sting when it's read and the harm to the reputation arises in the reader's mind?
Your Honor, I think the problem with that in internet defamation cases is that could be anywhere. And the whole purpose of venue, as Ms. Heim said, is to impose geographical limitations, to discourage forum shopping, which, again, respectfully, if you have an entire complaint about one county and you can throw in just one sentence alleging that it was read or understood in another county, how can that be enough to say that the cause of action arose there? And that, unfortunately, as Judge New pointed out, the federal statute, of course, has the substantial part language that, as Judge New noted, was not an arrow in his quiver in Pennsylvania. But I think there's sufficient case law in our brief that it has to be more than just this de minimis, one person maybe read and understood it. It has to be, again, some sort of anchor, which, at least in the persuasive authority cited in our brief, is where the plaintiff lives and works and where their reputation lives and breathes. So,
Thank you.
thank you, Your Honor.
Mr. Heim.
Good morning, and may it please the court. My name is David Heim from the law firm of Buchanan & Lentz in Philadelphia, and I represent the appellee, Joy Fox, in this matter. I think one of the main observations I have from listening to the justice's questions and opposing counsel's argument is that if it ain't broke, don't fix it. Because this system is not broke. The Catano case from 1967 has been referenced, and it's been discussed as, well, there's not a lot of cases that apply Catano. Well, why is that? I would venture to say because it works. It's not broke. The internet is not new. It has been around for over 20 years. This is the first instance that anybody has brought this type of case to this court's attention. If it ain't broke, don't fix it. And really what appellants are advocating here for is not for this court to overturn Catano. Really what they're asking for is the rules that are applicable to venue need to be amended, because all of the applicable rules say that a plaintiff can choose what county to file a lawsuit in if a transaction or occurrence took place out of which the cause of action arose. And that is precisely what the plaintiff chose to do here.
Mr. Heim, how do you respond to your opposing counsel's de minimis argument?
Well, and I'll go back to the restatement second and Catano's discussion of it. It's not de minimis to this cause of action that a third party who the plaintiff actually knows read and understood the defamatory statement in Philadelphia County. It is not de minimis. It is an essential part of the cause of action. If that doesn't exist, there is no cause of action.
Would it ever
There was
be
no
de minimis?
publication.
Can you come up with a situation where you would ever acknowledge it was de minimis?
If there were people in Philadelphia County who the plaintiff didn't know, not neighbors or associates or friends, that might be de minimis, because it wouldn't have caused reputational injury. But in this case, Ms. Kathy Clark is a close friend of the plaintiff, and she did view and understand the defamatory statement on the internet in Philadelphia. That fact is unchallenged in this case and undisputed.
Can I ask
It is
you
not
about
de
court
minimis.
a parent court can that standard, but perhaps I'm missing something. One, given your reliance on the language about a friend or someone who knows the plaintiff, ordinarily one might expect such people to view with a great deal of skepticism some defamatory allegation, where conversely it would be somebody who is not intimate with the plaintiff who would credit the defamatory statement and whose estimation of the plaintiff would sink. So can you relate to that question as it concerns reputational harm?
Well, sure. I mean, in this case, the allegation was that Ms. Fox committed felony crime years ago in North Carolina. That was the allegation. So for an associate of Ms. Fox who knows her, doesn't know her, her rap sheet or lack thereof, very well may have believed it.
Well, does the standard encourage, perhaps I'm far afield, but does that standard encourage disingenuousness? Because intimates of the plaintiff are likely, particularly in a campaign context, to view with great skepticism such averments. Whereas the general public, say people in Philadelphia who would have accessed this information on the internet, might take it at face value.
Well, I would say that might be a good question that the appellants could have asked in deposition testimony during jurisdictional discovery. But they chose not to do that. The allegations, as Chief Justice Baird noted, the allegations in the complaint on preliminary objections must be accepted as true. The allegations are plain in the complaint that this third party read, understood the statements to be defamatory of plaintiff. And that's all the plaintiff's burden is in these matters. If there were going to be depositions or jurisdictional discovery that challenged that could have happened, and it didn't happen. So what we are now in the state of this record, we have the allegations of the complaint. They are unrebutted.
It just leads me to wonder whether the focus of the standard is somewhat misplaced, because the harm is really then incurred by the plaintiff in Delaware County, but the connection, the nexus, is through this person who the plaintiff is constrained to allege actually lowered her own estimation of her friend, in circumstances where I confess a certain degree of skepticism that such friends will credit these internet allegations.
Well,
So can I follow up on that before you answer?
Sure.
I'm not even
Please,
sure it was a question,
please.
but
I'm sort of musing. Something you said made me wonder about
yeah, I
that
didn't
stuff.
mind interrupting the musing then.
Yeah, please, muse. Follow up my musing.
I will further muse. How are you going to prove the loss of the election attendant to this defamatory statement that was made in Philadelphia to someone who couldn't vote in Delaware?
Well, there are many damages in a defamation case, Your Honor. There are special damages related to financial harm and lost wages. There are general reputational harm that is available to the plaintiff.
And how does that work? You only have to establish that one person read it and found it to be defamatory, and then you can, your damages don't have to be related to that one person. Is that the theory?
Well, there are multiple theories of damages set forth in the complaint, and we haven't gone forward with all the discovery, Judge. But in a case like this, where the plaintiff is accused of committing a felony crime, it's defamation per se. And when it's defamation per se, the law in Pennsylvania is that the plaintiff only needs to establish general reputational harm. Doesn't need to prove I lost money, special damages. And under that theory,
you didn't bring this case to collect $1. I mean, obviously you have to establish damages related to the defamation, and this may be slightly off point, but maybe not so much, because this damage issue calls into play the relationship to the arena in which the actual harm took place that your opposing counsel is arguing is the appropriate venue standard.
it's not where all the harm took place. It's where some of the harm took place.
Well, isn't
There could be harm in Philadelphia County, and there could be harm in Delaware County. And when that occurs, the plaintiff has a choice of venue, which this court doesn't have a problem with and the rules allow for, particularly in a situation where you have all these voluntary choices that the defendants made pre-suit to post the defamation accusing my client of a felony crime falsely on the internet, to promote it on social media, and to do it about my client who happens to be a public person, so that the idea that my client, who is running for public office, may have a larger group of network and friends than maybe the average citizen should not be surprising to the defendants. That harm may have occurred in multiple counties since they chose to put this defamatory statement on the World Wide Web so all the counties could look at it.
Well, isn't your fundamental position here that venue is what gets you in the door, that Philadelphia publication and having been read in Philadelphia gets you in the door, and once you're in the door, we're not talking about venue anymore, we're just talking about, you know, liability and damages can be anywhere of any nature. Your Philadelphia issue was just to get you in the door through venue.
That's exactly right, Judge. The idea that, look, I think the venue and jurisdictional rules are basically set up to account for voluntary decisions that the defendants have made. Voluntary decision, if a business decides to regularly conduct business in a county, that's a choice. And the consequence jurisdictionally is they could get sued in that county. And if somebody travels to a different county and causes a car accident.
We're getting way far afield now.
Right. No,
I think we have it. Let me ask you, because I think this is sort of a nice case for you. The harder facts, which is what I think your opposing counsels argue, is somebody's running for mayor in a small rural county in North Dakota. And and we all know Philadelphia is an attractive jurisdiction to plaintiffs. So somebody in Philadelphia on the web reads about that, knows that person from a historical tie, thinks the reputational injury. Is there any difference at all? I mean, would your argument be exactly the same?
For purposes of venue, whether or not venue is appropriate,
Right.
different than whether or not venue is inconvenient.
Right.
For purposes of whether venue is appropriate, it would be appropriate. However, there's another issue of personal jurisdiction, which is a whole body of constitutional law under long-arm statute that we're not here about today.
And there's
forum nonconvenience. So there are already built-in checks for those hypotheticals, which I think are a little far-fetched, that this court should be worried about.
We're not worried.
Yeah.
Lydia, and what your point is, we don't have to change our venue rules, which I think Justice Dark.
They really don't. And if
We got it.
I would like to say one concluding point. The Gaetano case was decided in 1967. And I think the thrust of the appellant's argument is, boy, that was before the internet, and look at what the internet does. It allows this wide circulation and publication, and we might have to change the rules. But you know, in 1967, there were widely circulated publications. The New York Times, Times Magazine, the radio, television, widely circulated. The Supreme Court in 1967 in Gaetano knew that, and they knew that the possibility that somebody would use those mediums, there could be venue in many different counties. But they accounted for it by saying, there's got to be proof that somebody that the plaintiff knew actually ingested that defamatory material in that county. That's the check. And forum nonconvenience is another check that the judiciary has.
We got it, I promise.
Thank you.
Thank you very much.
argument is Commonwealth of Pennsylvania versus Eric Levadius Green. Representing Mr. Green is Mr. David Rudofsky. Representing the Commonwealth is Mr. Joseph Ruby.
This case pertains to a search warrant authorizing the search of all electronic devices located at a residence for evidence related to the possession and distribution of child pornography. At trial, the defendant filed a motion to suppress the evidence that was revealed during a search of his cell phone, arguing that the warrant was overbroad and that it failed to account for any of the non-criminal uses and information on the device. The trial court denied the motion to suppress. The Superior Court affirmed the order, holding the search was permissible and the warrant proper when the search of the device was limited to looking for evidence of the specific crime that the police had probable cause to believe the defendant had committed. And we granted allowance of appeal to consider the matter of the search of an electronic device which has vast amounts of information on it when the search is limited to the evidence regarding the crime. Mr. Rudofsky,
Thank you,
feel
Chief
free to
Justice
proceed.
Behr. David Rudofsky for the appellant, Mr. Eric Green. That is the issue. Our position before this court is that both the search warrant on its face and, more important, the execution of the search warrant in this case of the digital devices possessed by Mr. Green turn this warrant into a general, overbroad warrant proscribed both by the Fourth Amendment and Article 1, Section 8 of the Pennsylvania Constitution. As one commentator has said, when we look at the contents of our computers, our phones, our digital devices, if one gets into those contents, as in this case, and is able, as a police officer, to view and search every data point, every file, every image, every photograph in those digital devices, it's a way, as the commentator said, a window into our souls. And that's the issue before this court, following obviously the cases that the Supreme Court in Fulton and in Riley have said searches of digital devices and electronic devices are so different than searches that we've historically had of houses for guns or drugs and so on, that we need special rules to protect the privacy interests in these cases. The record in this case, and I'm going to point to 4 points in the record that fully support our argument that this was both a general warrant because of its overbroad authorization of what could be searched on the digital devices and the manner in which the search was actually conducted by the officers once the warrant was granted. The search warrant on its face authorized the search of all files, and I emphasize that, all files. Not only could the officer seize all the hardware, the officer was authorized to search all files and data on any of the digital devices, and then, as I say, seize all the hardware. The search of the phone, and this becomes very important, it'll be my fourth point, last point, was with what the experts in this area call a mobile device forensic tool, Celebrite. And searches of phones and of other electronic digital equipment, computers and so on. Today, law enforcement use Celebrite and other similar software tools to search. And the reason they do that is because in the extraction process, when they extract all the data from your phone, from your computer, Celebrite allows them to extract much more than a manual search would do. So if an officer, for example, was simply looking through a phone, trying to get text messages or images or emails that were sent or phone calls that were made, that gives a lot of information and would certainly raise privacy issues. But the process with Celebrite is it gets metadata, it gets history of access to apps, it gives the officer much more information than even a manual search can do. And the record fully supports our claim, and this is our first point, that the search here was of every file and every data point on the phone that was searched. The testimony at trial at pages 63 to 64 of the officer executing the search warrant said that he extracted all the data using Celebrite, that the Celebrite process processed and analyzed all of that data, and in the words of the officer, the search was, and I quote, whatever was on that phone. In other words, everything on that phone was subject to search, whether it fell within the definition of probable cause in this case or not for child pornography.
What's the alternative?
The
In other words, you mentioned in your opening the search of a home. The police are looking for a small quantity of drugs, but in a large mansion, they're searching through thousands of photographs or albums with photographs, books, apparel, kitchen utensils, etc.
I think a search like that has its own limits. If the warrant is for drugs or stolen property or a weapon, let's say, which is historically a lot of the cases this court has seen, the officer can certainly look throughout the house. Can't start reading in diaries, can't start looking at photographs, can't start looking at health records, can't look at privileged communications with one's client. All of that is out of limits.
Well, that may be true, but with respect to a computer search, there's no indication that all those files are going to be read, like reading a diary in a house or looking through a photo album for the pictures. In child pornography searches, they're not going to be finding files that are titled child pornogaphy.
But,
you know,
for sure.
Let me finish.
And there's this question about whether by deception, but let me be clear here. Why that, I think that principle doesn't apply, Justice Todd, here. Sure.
Mr. Radofsky, wait, Justice Todd's going to finish her question for you, then you can address it. We'll be done.
Yeah, that's all right.
Well, we won't be done.
So my point was when, as opposed to looking in the house, when you find a photo album or you find a diary, you're not entitled to read the diary, but you're entitled to flip through the pages to see if the drugs were secreted there. And with respect to a computer, you're not going to find a person who uses child pornography titling his files child pornography. He's going to title them other ways, and in order to figure out, for the purposes of the warrant, for the police to determine whether the child pornography is contained in these various files, isn't it reasonable to allow them to access all the files, not necessarily if it's a text file that, you know, they don't need to read everything, but they need to at least determine if there is pornography located within these various files. So that was my question.
Yes, and I'm sorry to have interrupted that. We understand that, and we understand that people normally won't mark a file child pornography or insider trading or something like that if it's a financial fraud case. But the Commonwealth's position in this case, supporting what the officers did, let me read from their brief. The Constitution permits the police to search in any areas of the device where the digital evidence could be stored, which could very well encompass all data files in the device. And they further say that could include everything on that device, privileged material,
Counsel,
medical records, and so on.
you indicated, or your implication is that this is a general warrant, but what about the self-imposed limitation that it's only to search for child pornography?
Okay.
Your argument may go more over breadth than general
That's
warrant, but my concern to you is you seem to be missing that point, that as Chief Justice said, you can go into a house and you're going to go through various items looking for the particular contraband. So tell me, how is this a general warrant when there's a specific limitation imposed by the warrant itself?
Because the Celebrite process that the officer used has two functions. One, it extracts everything, right? So the officer can now view everything that's on the file. And I get your point that the officer can simply look at that and disregard it. But the evidence in this case is that the officer searched whatever was on the phone, regardless of whether it had any indication of child pornography. And I point to you in the warrant itself, the officer says two very important things. On page 4 of the warrant, in examining computer storage devices, the officer says this requires searching authorities to examine all the stored data on the device. And the Celebrite method not only allows full extraction, but it also permits, by software, to focus on where the child pornography probably is. And here we have even more information about where the child pornography probably is, because at page 8 of the warrant, specific probable cause. The officer using Celebrite and knowing that these pornography files are usually shared by BitTorrent, that's what leads the officer to this particular defendant, was conducting undercover investigations into the internet sharing of child pornography. The officer was, this is before the warrant is issued, the officer was able to locate a computer which was sharing child pornography on the BitTorrent file sharing network using client software which was reported as uTorrent 3.3.
Yeah, but Mr. Radofsky, let's go back to the warrant, because the insinuation or your comments to me indicated that it was a overwhelming breadth of the search. Yet when I read page 4 of 12 in the search warrant, Corporal Goodyear specifically says, or writes, that he is a certified forensic computer examiner, knows that searching and seizing information from computers often requires investigators to seize all electronic storage devices along with related peripherals to be searched later by a qualified computer expert in a laboratory or other controlled environment. This is true because searching computer systems for criminal evidence is a highly technical process requiring expert skills in properly controlled environment. The way I read that part, that shares with me, at first blush, I think your argument's sound. Why the Commonwealth didn't include its search warrant in its briefs is a question that I have for the Commonwealth, because I had to go to the record to find it. But when I found it, I now realize that I've never seen such a more qualified search warrant from Corporal Goodyear with such detail, and he's even specifically negating your argument by saying, we're not having this broad search. We're looking for child pornography. Because of this criminal investigation is so intense, and because it's hidden, and this is big information, we're giving it to an expert in a qualified location to do a computer search that will locate the child pornography and will segregate that which is not. How do you challenge that?
Because the warrant on its face, plus the execution, for sure, this court has required the officer to say, we are looking for certain evidence of crime. That's what they did. That's necessary. Our point, it's not sufficient. What they did here was extract all the data, notwithstanding their knowledge, even before they executed the search warrant, that there were certain hash values connected to the photographs that they were looking for. They could have limited their search, both in the search warrant and—
Share that with me. How could they limit the search when Corporal Goodyear indicated that it's highly technical and requires expert involvement?
We all agree with that. The question is, when we say it's highly technical and need experts, that still leaves open the question of how broad was the search conducted in this case. If all they did was what you're suggesting, look for those files in which they had probable cause to believe that child pornography would be found, and they knew this in advance. They had the hash values on the files. They could have gone directly with their Celebrite software and found all the files that were associated with the files they already downloaded. They already had pornographic pictures from this computer, the same computer and the same phone that they examined after they arrested him and performed this search. They could have limited that search to those files. If those files then indicated some other areas, perhaps text messages, perhaps phone calls, they could go there. The problem in this case, and the record I think makes very clear, is they did much more than that. They read everything, or they potentially read everything. Sure, they were experts.
Where is that in the record that they read everything? So you, again—
I understand that, yes.
Permit me. The way I understand these facts, as I indicated, first blush, it looks overwhelming. But until you receive or read the warrants, there were actually two warrants. One was after the corporal downloaded and connected child pornography related to an IP address, a warrant was issued upon Comcast to locate the owner. Based upon that warrant and that knowledge and information, Corporal Goodyear now says he wants to secure all computer devices from that home, for which he only finds a cell phone and a laptop. He takes that laptop and he finds pornography. The information in the warrant is he describes only one particular photograph despite the numerous files he found in the initial search. He then takes that equipment and provides it to an expert and says, go search for child porn, and the expert computer technology people found child porn, and he got indicted with the numerous accounts. Share with me how that's overbroad or even general.
Yes, it's overbroad in the same way it was overbroad in Grossman. If you remember in Grossman, which this court found under Article 1, Section 8, which said it was a stricter particularity rule than even the Fourth Amendment of the U.S. Constitution, the officers had information looking at a paper search, looking for documents of criminal activity that those documents would show, whether financial fraud or whatever it was. They actually found 3 or 4 documents that, as in this case, 3 or 4 photographs that showed child pornography. They found 3 or 4 documents in Grossman. They also looked at, I think it was close to 2,000 other documents, which had, after they looked at it, they didn't know in advance, had nothing to do with the crime that was being investigated. And this court said that that search, that execution, turned that into a general warrant.
But that's not this case. This case is not one where, when the police were having the computer searched for child pornography, they found financial fraud documents, documents that indicated he was participating in a financial fraud, and then tried to prosecute him for that, and you moved to suppress that evidence. That's an easy case. That's a much different case.
No, I agree with you, but Grossman was not a case where what you can have in these cases, obviously, is this plain view doctrine, right? You're looking for child pornography and you come across some other evidence of a murder or something like that, and then you've got the plain view argument, and the court would have to deal with that in that kind of case. But Grossman was not those facts. Grossman, they actually found files that they were looking for. That was evidence of the crime for which the search warrant was issued.
Right.
But in their search process, and this is the point, this is our key point, I think, in the search process, they looked at hundreds, maybe a couple of thousand, of other documents. Again, under the same theory. Well, if we don't look at it and read it, how do we know it's not associated with this crime? A search that was more narrow than this search was, because this thing opened up the entire world, his entire world, to the police officers. And the court said, yes, you located 3 or 4 or 5 relevant documents. We're going to suppress it anyway because this becomes a general warrant. And the problem with digital devices, with all the forensic experts and all they're doing, how do we know? And I think the records suggest the opposite, that this expert limited the search to those areas where you were likely to find child pornography. By their own statements, what they say is, we have to look at every document, every photograph, every image, every data point before we can rule out.
With all due respect, Mr. Radowski, the warrant doesn't say that. I'd like you to show me where it does. It says that all these documents, collect everything, send it to the expert, and search for child porn. The warrant does not read, and it is an extensive warrant, 15 pages. It does not say read everything. It says collect everything, bring it to the expert, and search for the child porn. Completely different. So share with me, because you keep alleging everything. Where in the warrant does it give the Commonwealth unbridled discretion to search everything other than child pornography by an expert? Please, because that's the crux of your case. You show me, you win.
So I disagree on this point. The warrant authorizes the seizure of everything on that phone. We all agree. They extracted it. They extracted every piece of data from that phone. The warrant allowed them to do it. The warrant also said only search, as Your Honor says, only search for child pornography. Our view is the warrant authorized the seizure, and everything was seized from that phone, and the viewing and search of all of that to determine what was child pornography and what was not. If that wasn't sufficient to make it a general warrant, the manner of execution, as in Grossman, turned it into a general warrant. Because from the evidence we have in this record, and from the Commonwealth's own argument, the Commonwealth's own argument is we have to look at everything, regardless of all the information we have in advance of where the child pornography may be, which files it may be in. We have to look at everything, read everything,
All right,
before we can do it.
We've heard this several times now, and we get it. Yeah, okay. I was going to move on to another topic,
I have a
but
different view of what this warrant says, child pornography. Okay, now that could be read two ways. That could be read, look through everything, every email, every text, every financial document, until you fall upon some child pornography. Or it could be read to say, somehow you should use some search parameters that might get you to, that will get you to child pornography. I mean, there's a way to write this warrant so that it does not lack particularity. Take the Ori Melvin and Melvin cases, the second warrants that were issued in those cases. They contained 54, 64, 95 search words and phrases and things of that nature that limited the parameters of the search that was going to be conducted of the files that were contained on the computers. This doesn't do that. Is that your point? I mean,
It does, that's right.
Part of the problem. Let me tell you what I think part of the problem is. Nowhere do I see where you are suggesting what an appropriate warrant in this case would have looked like.
So,
Tell me,
yes,
tell me what this warrant should have said.
so exactly, 2 points on that. It's at least ambiguous, right? As Your Honor has pointed out, as to what could be searched. What we do know is what the officer said, how they searched it, and what they looked at, and what the Commonwealth supports in their brief, saying they could look at everything, they looked at everything, they're allowed to. You can have an ex ante or an ex post approach to this, or some combination. These officers downloaded, right, child pornography even before they got the search warrant. That gives them the file name, that gives them the hash values on that. They could have asked for a warrant, a more limited warrant, that authorized them to seize the computer, download everything, but only search using those guidelines, whether it's file names that they already had, whether it's hash values which they had, or the associated material. That could have been, and that would not be an overbroad warrant. The warrant didn't do that, even though the officers had given that information to the issuing authority here. We already pulled down several files. We know exactly where these files are. We know how they're marked. We know the hash values. We know the title on it. Easy search. This is an easy case that way.
Well, counsel,
Well, that may be 10 of the files, and there might be 1,000 files.
And that's right. And it's likely when you see that kind of information in advance that you know how this person stores their files, what hash values they have. Remember, he's downloaded those files from this BitTorrent, or this network. It's this file sharing network. That's their suspicion, and good probable cause, that he's downloaded, he's already gotten off the web, right, from other people, filed, shared child pornography. We know what those look like. And everything in this record suggests from the testimony at trial and on the motion to suppress that the experts, the forensic expert who finally looked at everything, wasn't limited by the warrant just to look there, and went much further and looked at all the files in this case.
counsel, you say all the files in answer to Justice Donahue, but my reading of the warrant indicates that they only collected those files that came from BitTorrent. BitTorrent being a child pornography center or the pass-through. So the reality is they didn't look through everything. This warrant doesn't say they have the right to look through every photo he has. They have a right to look for those items that are showing a BitTorrent, which is why you require expert, correct? And then they only secured the computer and the telephone, correct?
That's correct, Your Honor. But that's exactly my point, and I think it's the point that I pick up from Justice Donahue. Knowing this was BitTorrent, knowing that there were a limited number of files that were shared, it could have been 50, it could have been 100, whatever that was, there's a specific category of files here. It's this minute part of what he has on his phone or computer. He's got thousands and thousands of other files for which there's no probable cause. The issuing authority should have picked up on that and said, you're limited to use software, which they have, which is Celebrite, to trace BitTorrent files, which passed to Mr. Green. That would have been perfectly okay and would have fit Your Honor's image of what happened. We don't know that happened because there's nothing in the warrant that required the officer to limit his or her search
And can I
that
follow,
way.
counsel, isn't part of your point on this that the the legal paradigm needs to recognize the availability of these forensic tools to narrow and focus a search. Otherwise, it's tantamount to rummaging through files at will.
Absolutely. We have to understand what Celebrite is, this mobile device forensic tool, which, as I said, and it's referenced throughout here, and the amicus briefs, which is a good thing, it allows the police literally to extract every piece of data from your computer and your phones, but that raises the problem. Having extracted everything that shouldn't be looked at, Celebrite also, and these other tools also have software that can then target in and limit the search itself. Don't look at medical records.
Are you asking us to, and I want to move on. Justice Todd has a different area she wants to explore with you, and I think we've explored this. But are you actually asking us to write an opinion that says, in this world of electronic communication, for the warrant to be valid, it has to specify what computer software it's going to use to limit its search?
There are a couple of choices here. I don't think the rule has to be, and in fact, as Professor Kerr, who's probably the leading scholar on this, and he's written several articles, which you can read, the Harvard article also, doesn't ask for a court in advance, right, to say, this is the tool you must use, this is the way you must limit your search. Except in situations which I think fit this case, where in fact in advance you know, because you've already downloaded some of these files, where to look on this particular computer. That won't be the normal case.
So in rural Pennsylvania, they look through it looking only for child pornography. You would say that the warrant authorizing that and the search are both constitutionally overbroad?
If the officer does that, even without using Celebrite, and if you look at this is like Homing County. This is now, all police departments have access to this software. They've been using it for years to search phones, and they do it because it gives them much more powerful tools to extract the information. But even in the isolated case where the officer just decided to take the phone, open it up, right, and start reading text messages, what if he then goes to medical records? What if he then goes to correspondence with counsel?
What if is a
There has to be that limit.
All right, I think we've explored this. I understand it. Justice Todd has one other area she wants to explore, and then we're going to listen to the other side.
Thank you, Chief Justice. My concern with the warrant is with respect to how many computers and the different kinds of devices in the house could be searched under this warrant. In this particular case, there were only two, right? They go in and there's a phone and a computer, and that's what they take. What if the defendant was married and his wife's computer was in her study, and he had 3 teenagers who each had laptops? What precisely, in your view, is within the constitutional purview of the police to take? Can they only take the, and I'm not an expert, obviously, on how the IP numbers work and how they can identify which computers, but are they only going to be able to take the computers that are clearly registered to the defendant, or are they going to take everything? And what can they do?
I think there have to be limits, obviously. There could be the spouse, there could be the children, there could be business records and computers as well, as we all know. It's an extensive world of that. Using this case, it's clear to me that even if there were other computers in the house, the police could not have seized them because the probable cause they had was linked directly only to Eric Green, and they already knew that on his phone or computer they would probably find child pornography.
So they could zero in, if there are 10 computers, they could zero in on the 2 they're interested in.
That's right. Now, you could think of other cases using your hypothetical. Remember using this BitTorrent, right? This gives them very specific information because they're able, with the first warrant, to find out it's Eric Green's computer, right, with his number.
Let me just follow up.
Can I just
I'm
hear the
sorry.
rest of that? Yeah, go ahead.
Yeah, no, but my point is, unless they had probable cause that the spouse or the partner or the
Right.
child also was part of this network and also,
Right.
had this information on the computer, I think we'd all agree that they wouldn't be able to seize
Right.
those digital
Well,
devices.
my question, I guess, was more of a technical question than a constitutional question. The police are able to identify specifically the computers that they need to search and will not be permitted to bother the other computers in the home.
And beyond that, before I entertain another question, if I can, not only are they limited to that computer, but with the knowledge they have, which is the point I made before, they're limited to the files and data which are likely to have child
Right,
pornography.
we understand
That's-
that. Thank you.
Let me just, one quick question, and it's, I'll follow up to Justice Weck's concern and the Chief Justice's request is how would we fashion a warrant? Correct me if I'm wrong, one of the briefs for the defense, it may have been yours, it may be when you wrote an amicus, but one of those briefs indicate that the technology that you are indicating is necessary to make this specific warrant with particularity doesn't exist yet. So if one of these amicus briefs submitted to us says this type of technology does not yet exist, how can we fashion a order or an opinion saying because Pennsylvania requires specificity and particularity, we should indicate the type of computer technology that doesn't exist because it's so specific, other than that was outlined in the warrant? Would be my last question.
I think the brief said we don't have the perfect tool. When I talked about this,
Was that your brief?
yes, and there was also the brief from Upturn, which was the more technical brief. We don't have a perfect tool. Celebrite is not perfect in the sense that it can then limit the search, literally, right, to the files that would have the evidence of criminal activity. On the other hand, we've gotten 75, 80, 90% of the way there. In this case, Celebrite had already indicated which files, which photographs, hash values, file headings would contain child pornography. You can exclude everything else. And if you're concerned about a case in which we don't have that information in advance, these tools also have a very interesting confidence level prediction. Let's say you're looking for bookmaking, right, on a computer. But you're concerned that somebody might not say bookmaking, so they go bee-making or something like that, right? And you think you're going to miss that file. This software actually has the capability of saying, if you say bee-making, you've got a 70% chance, right, of finding bookmaking. There'll be that kind of relationship. So the point is, we don't have the perfect tool yet. We may in the future at some point to limit the search. We have a tool that's perfect at extracting everything, and the same tool is close to perfect in identifying those files and avoiding, which I think we all agree, overbroad and indiscriminate searches.
Could I follow up briefly?
I have one
Chief?
question. I'm just curious if in the underlying trial court, whether there was any expert testimony substantiate your position with regard to the capabilities of these softwares.
The officer, yes, both at the suppression hearing, but more at the trial, the officer described the process they used, the Celebrite. And I'll read from...
Other than the police officer, was there a defense expert to describe the capabilities of the software to support your
The
testimony?
defense did not present any other evidence to talk about what I'm talking about, but the testifying officer did, and I'll just read to you this one sentence, page 63 to 64 of the trial record when he's describing what happened. A physical extraction examines, this is the physical extraction by Celebrite, examines the chip of the phone bit by bit, extracts the data from the phone, and then Celebrite physically analyzes and processes that data. That's the point. He made the point that it both extracts, analyzes, processes, and gives to that officer all that information which they can view and search. Our point, and I don't want to repeat myself, is that this turns this into, even if the warrant was okay, the execution of the warrant turns this into a general search.
Could I just ask the question I wanted to ask? Isn't it your part of your argument that in 2021 we no longer can ignore the availability of these technologies, which allow a firewall, which allow the equivalent of a taint team, in order to prevent the robust invasive powers to prevent rummaging in the electronic world that we now live in, as opposed to the one we lived in 100 years ago?
I think that's fundamental. Riley and Fulton make that point. Riley says a search, right? And then the point about the search of the house, Chief Justice Roberts said a search of our digital equipment is so different from the normal searches that we usually do. We need special rules for warrants. That's exactly right. The technology is there. We can't ignore it. And without it, you're going to continue to have general searches on these warrants. That's our fundamental point.
Counsel, just one more question as to what the warrant should have said or could have said. If it was limited to a search using available technology to extract files relating to child pornography, would that have taken care of the issue?
I think in this case, not quite. It should talk about available technology, and obviously the application for the search.
I asked you the question earlier. What would it take?
Right. So it would take, knowing that it was Celebrite, because that's what the officer said, we're going to use Celebrite to extract, and we've already gotten it. Not knowing how Celebrite works, the officer should have submitted the warrant asking for permission or the power to search for all those files that have already been classified as child pornography by hash value, by title, or by indication, and any other information that those files would lead to. It may be, for example, if the download was on a particular date, you could then do metadata as to what other entries there may have been in the computer about that date. So it can lead to further things, but there's got to be some limitation. This was a completely open-ended authorization, and that's what the officers took advantage of.
Thank you very much. Mr. Ruby. Interesting second argument today involving new technology and the challenges to ancient law.
Thank you, Mr. Chief Justice, and may it please the court. Joseph Ruby for the Lycoming County District Attorney's Office, representing the Commonwealth in this case. The search warrant at issue in this case is not unconstitutionally overbroad. Because it described the items to be searched for and seized as specifically as was reasonably possible. This was not a warrant that permitted rummaging around to see what evidence law enforcement officers could scare up of some crime. Rather, this was a case in which law enforcement officers knew a particular crime had been committed, and the search warrant narrowed down to where to look for it as much as it reasonably could, and by its own terms, limited law enforcement officers to looking for evidence of just that crime. So really, to jump to the heart of it, the question that is really posed by the defense is, how is this case different from Grossman? Can one single sentence in this warrant, these items will be seized and then later searched for evidence relating to the possession and or distribution of child pornography, can that make it different from these warrants that we have in other cases that say you can search any and all items without limitation? Can that make it different from Grossman? And I want to be clear about what the issue was in Grossman. In Grossman, the issue was that law enforcement officers knew that a particular person was committing fraud, and they could have walked into Mr. Grossman's office and left that office with the Dorman file, the Watson file, and the Jones file in a briefcase under one of their arms. But instead, they left that office with 8 cabinets full of files to be analyzed and looked through everything, because the search warrant did not limit them into what they could look for or look through. There was no standard by which the search warrant would prevent them from doing just that. But with the limitation that's included in this warrant is not authorizing law enforcement, the warrant in this case is not authorizing law enforcement to go in and take 8 filing cabinets out. This warrant is authorizing law enforcement to open each of those 8 filing cabinets, look through until they find the Watson file, the Dorman file, and the Jones file, and to take those files.
Although they did metaphorically take them out in the sense that the files now can be contained on your cell phone, which has enough computing power, I guess, to hold an encyclopedia, and they took the cell phone out. So how do you, argue that it's distinct from taking all of the filing cabinets out if they're all reduced to this memory, this digital memory. And is there anything wrong with that?
Certainly, Mr. Chief Justice, the difference is that in the context of 8 filing cabinets full of 2,000 files, a physical search, while that's a lot of documents, it would not have been difficult for the police to identify those files on site and walk out with those 3 files. As noted throughout these cases, the amount of information stored on a cell phone is enormous, and really it comes down to doing something as specifically as reasonably possible, describing with as much specificity, and there's simply not a reasonable way to take the child pornography files without seizing the entire cell phone to be searched by experts later in the process.
Well, and I think the argument that your friend makes is that once seized, if I understand, we should say that technology is now cut off. You should use the Cellbrick system or some system which will selectively search the phone and ignore the benign information on it. And what's your response to that?
So, 2 primary responses to that. First, as I think it might have been Your Honor who noted, different law enforcement agencies are going to have access to different tools. The technology is changing so rapidly, and this is acknowledged in all of the cases. 2 years from now, 4 years from now, criminals who are downloading child pornography may have gotten a tremendous technological advantage, or law enforcement agencies may have gotten a tremendous technological advantage. But this court should very much be cautious when relying on technology as it exists today to write an opinion. But perhaps the second point I want to make about that is one that fits in broadly and I believe is responsive to the argument that it was not just the way the search warrant was written, but the manner in which it was conducted that turned it into an overbroad search warrant. From the beginning here, the defendant, Mr. Green, could have said, the way you conducted this search warrant went beyond its scope. Officers, get on the stand and tell me how you conducted this search warrant. But he did not do that. He made a 4 corners argument to this search warrant, saying that on its face it was not particular. And so there are broader principles here, and a lot of the cases cited in this jurisdiction, but especially other jurisdictions, talk about ex ante limitations versus ex post review. And one quote that I believe is a federal case, Burgess, but it's cited in a number of cases, both federal and state, and I think it applies, it expresses the majority view that ex ante limitations are generally disfavored. And that quote is that it would be folly for a search warrant to structure the mechanics of the search. It is unrealistic to expect a warrant to prospectively restrict the scope of a search by directory, file name, or extension, or to attempt to structure search methods. That process must remain dynamic. And that's in the specific context of electronic searches. And that leads to a case that both amicus briefs cite favorably, and that the Commonwealth also believes contains a very balanced, conscientious discussion of many of the issues here in this case, and that's U.S. v. Christie. It's a 10th Circuit case written by then Judge Neil Gorsuch. And in that case, then Judge Gorsuch makes the point about ex ante limitations being generally disfavored, but then says it's really important that we have ex post review, that we have the possibility of robust ex post review. Now, where I think perhaps the Commonwealth's position differs from that of defense is it's the Commonwealth's position that that ex post review was always available to the defendant in this case because the search warrant at the beginning laid out a standard by which its execution could be judged, and the defendant simply chose not to contest, and I won't speculate as to why.
Commonwealth.
Yes, sir.
The question of concern is you compared the facts of this case to Grossman. But in fact, Grossman dealt with 3 specific individuals, and there's talk about, as my friend Justice Weck said, this alleged rummaging. The question I have is how, whether it's rummage or search, how do you search for pornography when your expert on page 4 of 12 specifics of search and seizures of computer system specifically indicates that in child pornography, it is quite common for the pornographer to deceptively name files inconspicuous names as opposed to 12-year-old blonde girl or something that is something obvious. So how do we go about searching that without looking at the content when the name or for the search is proven to be irresponsible based upon this type of criminal activity?
That really is the difficulty facing law enforcement in this case, and I believe it's the Commonwealth's answer that there's no reasonable way to do that search without potentially opening up files that are labeled 2009 tax returns and seeing whether they are in fact 2009 tax returns or child pornography. And certainly the experts who conduct these searches are using tools to say, return me images, if they know they're looking at images of child pornography. They are doing this, and they are getting back a folder full of images, but...
Follow up on your answer to Justice Daugherty?
Yes, Your Honor.
Because I think we can all agree readily that there's plenty of potential for deception, and one would expect deception in labeling. Can you, in regard to the response you just gave, can you explain why, given the availability of technology and the availability of firewalls or the technological equivalent of a taint team as described by the Vermont Supreme Court, why we shouldn't require such protections in this day and age, in this area? In other words, I'm wondering whether our law has kept up with the technology in this area, and if you could give your position on the firewall availability, such that in effect, the experts doing the screening would be walled off from the the principal investigators.
Certainly, Your Honor, and there are 3 things I want to say in response to that. The first is to once again go back to U.S. v. Christie, and one of the reasons why Gorsuch said that ex ante limitations are often disfavored is because a magistrate making this decision on the front end, a magistrate is not going to be an expert in these sorts of things. The things that are requested of or suggested to the magistrate are not going to be tested by litigation adversarially, whereas ex post review is going to provide for both sides to put forth their experts and their testimony and to have a judge make that determination in a much more comprehensive manner. The second thing I'd want to say is that even as recently as a couple years ago, a case that is cited in amicus brief, the ACLU brief, Wheeler, the Delaware case, they continue to say at this point, listen, ex ante limitations are simply the minority view, and there's a number of technical difficulties that simply do not bring them into the realm of what is reasonable, and that's simply based on the nature of electronic searches, which cuts both ways. The amount of information on a cell phone certainly cuts in the direction of privacy, as discussed in Riley and Fulton, but also cuts in the direction of it is becoming easier and easier for a sophisticated criminal to hide what they're trying to do. And the third thing is perhaps starting to go in a new direction, but I wanted to circle to the Vermont case, the in re application for search warrant that imposes ex ante limitations. And I certainly submit that a full reading of the cases shows that that's one of the only cases in which that was done, that is still definitely not the norm. The Vermont case simply said it's not unconstitutional for a magistrate who's looking at the particular facts of a particular case to impose certain ex ante limitations. The Vermont case did not say the absence of those ex ante limitations is affirmatively unconstitutional in all cases. And the Vermont case went on to say that if the magistrate imposes those ex ante limitations, then the magistrate really has no reason or no right to abrogate the plain view doctrine on the back end. And now some cases, such as the Oregon case cited in the amicus brief, Mansour, abrogated the plain view doctrine in some way on the back end of things, ex post, but in doing so said, listen, we're not considering whether ex ante limitations are required. We're not even considering whether they're appropriate for any of these cases. So I think the point I really want to make with that is that when the defense says, when appellant says what is constitutionally required by the Pennsylvania Constitution is a blend of ex ante and ex post limitations, this court should consider that invitation cautiously in the sense of, well, what is the answer to what is necessary? And this court should recognize that that request goes beyond what any other jurisdiction cited by any of the parties in this case has found to be constitutionally necessary.
Thank you.
Justice Todd has one last question.
Yeah, counsel, in following up on a dialogue I had with your opposing counsel, can you confirm that within the scope of the warrant in this case, the police would not have been entitled to seize any other computers in the house that may have belonged to other family members, and that as a matter of technology, they were able and would be able to pinpoint the computers that were owned, registered, used by this defendant?
I'm not sure I can confirm that, Your Honor, and what I believe happened in this case is that the state police in their search were able to determine that a device connected to this IP address was having child pornography pass through it. It was both downloading and sharing child pornography. The state police went to the service provider and found that that IP address was registered to Eric Green at this address.
And is that with respect to one device, or could that have been multiple devices?
That could have been multiple devices because from a technological standpoint, the best specificity they're going to be able to say is the IP address is basically attached to the modem, and then any device, it could be 2 computers and 3 tablets, hook up to that modem. That IP address describes each of those devices. And what I
Which could be
believe,
the husbands, the wives, and the kids.
yes, Your Honor, and what I believe the Pennsylvania State Police did in this case is they went to this house and they found Mr. Green's phone and turned it on and saw that it had torrent and saw that it appeared to contain images of child pornography, and they seized it. And they went to his child's school computer and saw that it was there. Could not at that time say with any greater specificity whether that was the device used, and they did turn it on and saw that it did not have torrent and that there was no indication that it had child pornography, and they did not seize it. They left it at that house. And that's why the return on the search warrant had just the computer and the phone.
So you would expect they would do that then with any computer they would find in the home and only take it, only actually seize it if it was suspected to have child pornography on it?
I would suspect that. I would state that that is what is required by the search warrant, and I would state that if the defendant believes that the officers executing the search warrant have gone beyond that, that is certainly something that the defendant could challenge on ex post review at a suppression hearing.
Thank you.
Thank you. Well said, thank you.
Thank you, Your Honors.
The constitutionally required burden of proof for denial of bail and the application of the best evidence rule to text messages. Article 1, Section 14 of the Pennsylvania Constitution provides all prisoners shall be bailable unless sufficient sureties, by sufficient sureties, unless, among other reasons, no condition or combination of conditions other than imprisonment will reasonably assure the safety of any person in the community when the proof is evident, presumption great. And the first question is, what's the quantum of proof required by the language proof is evident or presumption great? The second issue, appellant contends that the admission of the printed screenshots of text messages violated the best evidence rule, both questioning whether the screenshots are duplicates or originals or something in between, and additionally, whether the best evidence rule requires hyperlinks and metadata and the like when the screenshot is entered. So that's an accurate recital of why we're here today with yet another technological question. Ms. Ernst, you can begin.
Thank you, Mr. Chief Justice, and may it please the Court. My name is Catherine Ernst of Wiseman and Schwartz on behalf of Daniel Talley. I'm going to begin with the bail issue, and then I'll move on to the best evidence rule. According to the Commonwealth, a criminal defendant can be denied bail after nothing more than a proffer upon the lowest burden of proof, and even though the defendant is only charged with misdemeanors. Such a procedure violates the plain language of Article 1, Section 14 of the Pennsylvania Constitution that Chief Justice Baer has already read. So the standard contained in Article 1, Section 14 is that the proof is evident or the presumption great. This was language that was written by William Penn back in the 1600s, which is why the wording is a little bit awkward to read. But to try to transform this into a modern standard, it suggests a clear and convincing standard, and that it. Well, by our modern ears, it's a bit awkward. I'm sure it was very lovely back then. So the word evident is a synonym of the word clear. So that's the first starting point, looking at the language of the constitutional provision itself. And beyond that, this court has continuously held as well as the United States Supreme Court, that when you determine what a burden of proof is, you look at what interest is at stake, and therefore which party should bear the risk that an error is made in the decision. And so when only money is at stake, a preponderance standard is appropriate, because then each side bears the equal risk that a wrong decision is made. If criminal conviction is at stake, then the Commonwealth should bear almost all of the risk and have a proof beyond the reasonable doubt standard. Where something more than money is at stake, a clear and convincing standard is required, and that's what this court said in Commonwealth versus Maldonado in 2003. And in fact, it must be noted that the Commonwealth is not even arguing for a preponderance standard. They're arguing for a prima facie standard, which is even lower, which would essentially shift all of the risk of wrongful imprisonment on the defendant. So under the standard of Article 1, Section 14, the Commonwealth has to prove two things based upon the language of the provision. They would have to show that the weight of the evidence is strong, so the proof is evident that there is a likelihood that the person committed the crime, and also that there's no condition or combination of conditions that can reasonably assure the safety of the community. And the Commonwealth cannot meet this burden by proffer. Aside from the fact that the Commonwealth is never permitted to meet its burden by proffer in any other criminal context, it must be the case that they cannot meet their burden by proffer, because a proffer would not allow the decision maker to assess the weight of the evidence, which is a part of the claim.
Counsel,
Yes.
following your theory, defendant's arrested. At arraignment, he's sent to a bail commissioner for the establishment of bail. This is before a preliminary hearing. Is it your position that now at the bail hearing there must be a pre-preliminary hearing where evidence must be adduced? And if so, why have a preliminary hearing?
That's an interesting question, Your Honor. I would say that, a preliminary hearing is supposed to be held promptly. And obviously, there does need to be some amount of time in order to marshal the witnesses that are necessary for such a hearing. And so I don't know that I could say that I would object to this, decision to be made preliminarily, awaiting the preliminary hearing when the witnesses can be brought forth, as they would have to be brought forth for the preliminary hearing anyway.
So you suggest that the victim should be dragged into a bail hearing and then then invited back to a preliminary hearing. Under the rules of bail, it's to secure the defendant's appearance, correct?
Yes.
And it's to look at the community of the safety, and we now know if we want to incarcerate, otherwise you can create bail. The question or concern is, what is the basis for the introduction of a complainant to prove the elements of the offense at a prima facie level to determine whether he's going to appear at the hearing? It seems to negate and erase the rules of procedure for preliminary hearings. I'm not following your logic.
I understand what Your Honor is saying, and what I'm saying is that the standard here to continue to detain someone is clear and convincing evidence, and that would require some level of proof. And as I said, I don't know that there would be any constitutional difficulty with delaying that for a short period of time until the preliminary hearing. Obviously, an initial bail determination would have to be made.
So are you distinguishing if the Commonwealth is seeking to keep the individual or place the individual in jail, there's a clear and convincing standard. But if it's not, and it's just the bail to assure his appearance or her appearance, then monies can be set? Can proffered evidence be introduced for the purposes of establishing a monetary basis?
Yes, and that's a very good point, Your Honor, and thank you for raising that, is that there's also a distinction between when the initial bail decision maker is setting bail and the amount that he or she is setting bail at, versus if the Commonwealth is asking that no bail be set. And that's a critical distinction because of the way that Article 1, Section 14 is written. It says that all prisoners are entitled to pretrial bail unless the Commonwealth can make this showing.
What protects, if I follow your logic, what protects my client as a defense attorney if the Commonwealth wants to use that as a ruse and said, I'm not seeking incarceration, so I don't have to do a clear and convincing evidence. I just want to do a bailable, a monetary fee, but I'm asking for $100,000 and I'm the public defender and my client's indigent and homeless. Now what happens? Did he not get the incarceration that the Commonwealth wants with the lesser standard? Isn't that hypocritical?
I agree, and there are arguments to be made that that would be a functional bail denial, and so if the Commonwealth were asking for a functional bail denial, that the same standard should be utilized as an overt bail denial. But if reasonable bail is set, which is what the Constitution requires, then a proffer may be appropriate. Whereas if the Commonwealth wants to hold someone indefinitely without them having any ability to obtain their release, that's when they have to make this showing.
Fair enough. Thank you.
Thank you. In this particular case, Mr. Talley had no criminal record. He had significant ties to the community. He had custody of his young daughter. He was gainfully employed, and he was only charged with misdemeanors. And the Commonwealth asserted that nonetheless he was, a danger. They didn't present any testimony or any sort of even hearsay from the officer to establish this. And moreover, they didn't present any evidence regarding what conditions of release were available and to show that no combination of conditions.
What us to do about it now? The bail hearing, and I guess this is generally going to be true unless you take emergency appeals or the like. We can set the standard prospectively at clear and convincing. I guess as an academic matter, we can talk about whether it was met by the Commonwealth through circumstantial evidence in this case or not met. But, unless you're going to bring a civil rights suit after the fact, it seems as if the issue's moot.
So to that, I would say, Your Honor, what I have argued in my brief is that what the case law in Pennsylvania and elsewhere holds is that if the defendant can show that the bail denial impeded his ability to defend himself at the ultimate trial and change the outcome of the case, that then the issue is not moot, and in fact, he would be entitled to a new trial. And that is what we assert happened in this case. And so if this court would agree that there was an error made, and I would point out that while the proof is evident and presumption great has not been interpreted in a modern standard of proof, it has always been the case that the Commonwealth bears the burden of proof, whatever that burden may be, at a bail hearing. Here, the hearing was held after the filing of a Rule 600 nominal bail motion, and they didn't present any evidence. So regardless of what this court finds the proper standard should be, there was clearly error by the court not requiring any evidence to be submitted regarding the conditions
Follow
available.
up on the Chief's question,
Yes.
Counsel. Supposing for a moment that there was an error in denial of bail, following up on the Chief's question, what now? Given that you didn't file an appeal in the interim on the denial of bail, we're constrained to try to figure out if you have any basis for saying it affected the outcome of the trial. And in that regard, you've asserted there was a cease and desist letter and that there were the Facebook message. But my understanding from the record is that you never even came up with those alleged documents. My understanding, and correct me if I'm wrong, is that that evidence was never even presented. And in the absence of that, how are we able to conclude that the denial of bail affected the outcome of trial? In other words, how was he prejudiced?
Yes, Your Honor. What I would say to that is that if this court were to find that there was error, then it's the Commonwealth's burden to prove beyond a reasonable doubt under Commonwealth versus Story that this error was harmless, if we're applying a harmless error analysis. And I don't believe that they can meet that burden. And the reason is because this was an incredibly close case. It was a misdemeanor trial. The trial lasted 2 days. The jury deliberated for 3. They asked 9 questions, including asking to be re-instructed on reasonable doubt. At one point, they indicated that they were hung. They ultimately did hang on 2 of the counts. And so in a razor-thin case, when the defendant cannot assist in his own defense, it's going to harm the outcome of his case. There's a lot of data that's presented in my brief, but especially in the amicus briefs, that discuss how it makes it significantly more likely that you will be convicted if you are detained pre-trial, especially under the circumstances where the way that the jail works in Montgomery County, Mr. Talley was held in maximum security lockup because his bail had been set so high initially, and so he was not even able to access, the prison library or anything else in order to assist in his own defense. And to the point that these documents were not presented, it is because Mr. Talley was not able to assist in his own defense and locate these documents that they were not presented in the first place. So for all of these reasons, that is why the Commonwealth cannot prove beyond a reasonable doubt that this bail denial didn't affect the outcome of this case.
And when we review this issue, are we limited to the record made at the bail hearing as opposed to at trial?
So I would say that in order to assess whether this error was harmless at trial, you would of course have to assess what happened at the trial. Of course, part of the Commonwealth versus Story test of harmlessness includes an analysis of whether there was overwhelming evidence of guilt. If there were overwhelming evidence of guilt, then plainly this error would not have changed the outcome of the case, but that is not true here. This was a razor-thin case.
How does it impact the case if there's sufficient circumstantial evidence entered at trial to show that if the Commonwealth had been aware that the burden was clear and convincing at the bail hearing, they would have met that, or that the totality of the evidence in the case shows clear and convincing evidence that defendant should have been confined without bail because the victim could not be kept safe without him being convicted, being incarcerated?
If I think I understand what Mr. Chief Justice is saying, I have 2 responses to that. One is that on a harmless error standard, you don't use the sufficiency of the evidence standard. You assess the entire record to see whether the evidence was overwhelming. But as it relates to, I believe you are suggesting that, well, what if you could show that that the prosecution should have prevailed at the bail hearing had they presented the evidence that they had. And to that, I would say that we actually have definitive proof in the record that if evidence had been presented, Mr. Talley would have been released. And the reason that we know that is because the prosecutor stated during the bail hearing that it was his understanding, based upon hearsay from people in his office, that someone from the probation department had stated that they didn't want to do pretrial ankle monitoring. And as it turns out, that's not true. If the court would have ordered ankle monitoring, then he would have been released, and the judge, in his opinion, stated that the reason he denied bail was because of his misunderstanding that it was not available.
It was unavailable. All right, thank you. Anything further? Anything you'd like to say in conclusion?
No.
Oh, you have to turn
I
to
still
the
have the
second
best
issue.
evidence rule.
Oh,
Yes,
go
thank
ahead.
you. So, anonymous text messages formed nearly the entirety of the prosecution's case. The critical disputed issue was whether Mr. Talley was the sender of these messages, and yet the Commonwealth refused to hand over a complete original of the messages to Mr. Talley. The heart of the best evidence—
When you say that, do you mean hypertext and metadata?
No. So the way that the screenshots worked in this case is that the alleged victim, screenshots are just pictures of what's on the screen. She took a series of pictures. Those pictures primarily, the first thing to note is they cut off portions of the messages themselves. The defense attorney objected twice during the trial, saying, Your Honor, this message is very visibly cut off, and there is no continuation in the next screenshot. So we have no way of knowing how much of these messages were omitted based upon the fact that the messages themselves were entirely cut off. So that's the first point. And
Were they
really,
offered- I'm sorry, but just to follow up, were they offered to establish the identity of the sender?
so
Is that where they were offered?
So the messages were offered really for both reasons. I mean, one, to just, of course, prove the content of the messages themselves. And then the content of the messages is what the Commonwealth argued proved the identity of the sender. Because Ms. Nesbitt testified that there were certain song lyrics or things in the messages that made her believe that Mr. Talley was the sender of these messages, even though the messages themselves purported to come from a different ex-boyfriend who was the father of her child.
That was your client's theory, but the messages themselves didn't show anything about that, did they?
All of the messages themselves purported to come from this other person. The messages repeatedly said,
We're a little bit into the factual weeds, but I don't understand when you say purported to.
so the messages said, give me back my daughter. And her other ex-boyfriend is the one who had a child with her. And they said, they basically said that they came from this other person. There was also some messages that said that someone was being paid by this other ex-boyfriend to have them send her harassing text messages on his behalf. So the messages themselves stated outright that they came from this other individual. And, but she testified that she believed that the content of the messages proved that they came from Mr. Talley. And so that's why I said to Your Honor that it really established both. So to just...
Is there any evidence that the screenshots were available? I mean, they sort of, I'm sorry, that the original text messages remained available, because they get buried very quickly in your phone.
So, yes. So Ms. Nesbitt, the victim in this case, she had her cell phone. She brought it into the police. They held the phone in their hands. She testified that she didn't object to them inspecting the phone, downloading the messages. It's not difficult to download phone messages, as you know, the last argument talked about. And of course, the Commonwealth here had the ability to do a full download and then have, you know, a full string of the messages. But even litigants less savvy than the Commonwealth, there are many programs that allow you to just download all of the messages so that you can print them out for court, and so that there aren't omissions and of the messages themselves, as well as there are not omissions of the to and the from fields and the time or the hyperlinks, all of which were parts of the electronic document. And what the rule, the best evidence rule states is that if you wish to present an original, and if the original is a electronic document, then an original is a printout that accurately reproduces the information contained in the electronic document. And these screenshots simply didn't do that because they omitted portions. And that is why they do not meet the best evidence rule. And because of that, her testimony regarding the messages should not have been permitted. The screenshots shouldn't have been permitted. And Mr. Talley is entitled to a new trial with the, after they've turned over the original messages.
Thank you very much. Mr. Conable.
Good morning. May it please the court, Stanley Joseph Conable, Assistant District Attorney for Montgomery County on behalf of the Commonwealth. The Superior Court correctly concluded that the trial court did not abuse its discretion in denying defendant's motion for nominal bail. Regardless of whether the standard is prima facie case or something higher, the affidavit of probable cause, which defendant at the bail hearing agreed the Commonwealth could rely on, linked defendant to the many harassing and threatening text messages the victim received, and it set forth what the Superior Court described in its own words, compelling proof that defendant shot at the victim's car. While there's no law precluding the Commonwealth from relying on a proffer at a bail hearing, there was also a later hearing on defendant's motion for reconsideration. There was live testimony there, and the trial court considered that in upholding its earlier ruling. And as Your Honors have noted, there was no appeal of that under Pennsylvania Rule of Appellate Procedure 1610.
So you're not presenting argument to us on what the standard should be in light of the constitutional language. Rather, you're saying regardless of what standard we determine, you met it.
Well, Your Honor, I would note that, to answer your question, under Alberti and Ferris cited in the parties' briefs, This court has previously interpreted Article 1, Section 14 to require only prima facie showing. So that constitutional provision was amended in 1998 to include to broaden the class of offenders included under that provision, but it didn't change the language. So the standard remained the same, class of offenders expanded. So the Commonwealth's position is that the standard under this court's precedent is a prima facie showing. Now, I am acutely aware that the standard is really what this court decides it is, and if it decides that, subsequent to these amendments, it needs to be different, then we are also arguing that even under some kind of heightened standard, defendant's motion was properly denied. And I would note that proof is evident, or I'm sorry, it's very hard to memorize that language, but proof is evident or the presumption great. Prima facie showing under this court's precedent. Other states have said this is sui generis. This is not reducible to any other sort of evidentiary standard. It's kind of in its own category. Others equate it with clear and convincing. So really, if you do a survey of the case law across different states, it's all over the map. So the Commonwealth's position, though, is that as it stands, that language means prima facie showing.
And assuming arguendo that you were required to have clear and convincing evidence, you did not have clear and convincing evidence, did that impact the actual merits of the trial?
No, Your Honor.
Providing him so we should provide him with a new trial?
No, Your Honor.
Seems attenuated.
Yes, I agree, and I would have several responses to that. So the first is that before we get to error, the court has to conclude that the standard is not a prima facie showing, that it's something higher, and that the court failed to apply that standard, and that applying that standard, the court abused its discretion. So before we even get to an error, I think you have to go through all those steps. And you look at the transcript from the bail hearing, the motion for reconsideration, you look at the 1925A opinion, it's not clear what standard was applied. The court said, I found that there was no condition or combination of conditions that would ensure the safety of the victim. Well, what was the quantum of proof underlying that? It's not really clear. So I think, you can look at the Superior Court, which said there's compelling proof that he shot at her car the same day or, the next day after he sent her some text messages suggesting she was, physically threatening her, saying she was going to be sorry.
What's a little bit messy here is that, and I tried to probe this with opposing counsel, that I think reading the trial record, there may be circumstantial evidence that he should not have been permitted out on bail because of a threat to the victim. But of course, the trial evidence wasn't in the record at the time that the bail was decided.
A lot was in the record, though, which was the numerous harassing messages, the fact that he was arrested, and in the same day he was released, he sent her more text messages. I believe that the firing the shot at the victim's car.
He was arrested, released, and rearrested. Is that right?
Yes, I believe my understanding is that we filed the complaint, withdrew it, and then refiled because the conduct continued. So that was all in the affidavit of probable cause, and all that was testified to by Detective Charlanza at the motion for reconsideration hearing. So again, you would have to decide that it's not a prima facie showing, it's a higher showing, and that the court abused its discretion, which is a very deferential standard of review, given all the evidence before the court at the bail hearing initially and the motion for reconsideration. Yes, Your Honor.
Evidence that electronic home monitoring wasn't available. That's what the trial court wanted to do.
The trial court, and I've read this several times because I've been very concerned with this issue for obvious reasons, the trial court at the bail hearing said, why can't we do this? So the trial court never specifically said, I would have done this. Now you can make that inference. I would agree, you can make that inference.
Well, the Constitution asks you to look at if there are other alternatives available. So what was the evidence that it was not available?
This was at the initial bail hearing, and the prosecutor represented to the court that the ankle monitoring was not available for defendant. And
Indicated, I mean, was there, who indicated?
He mentioned some higher-ups in the office. I can tell you that there are some citations in defendant's brief that other defendants have gotten ankle monitoring prior to sentencing. I remember, again, this is outside of the record, so please stop me if this is not responsive. I remember prior to our oral argument before the Superior Court, I called the probation office and I said, why can't you let this defendant out? And they told me that they couldn't put him on ankle monitoring because he had given him an out-of-county residence. Now, I looked inside the record, and there is a motion for an application for parole dated September 7th, 2018. He gives a Nottingham, Pennsylvania residence, which is in Chester County.
But that's not, that wasn't the rationale that was provided to the court.
Well, the prosecutor said...
Rationale was, it's not available, and...
I do believe he said prior to sentencing, is my recollection. And I do think that that would be the case, because my understanding is that after sentencing, a defendant may be put on probation, and then if they're out of county, that county supervises that person. So we have to actually transfer their supervision to a different county. So we're not supervising people in like Philadelphia County or Chester County or these other counties. They do courtesy supervision for us. And so my understanding, and that's all this is.
Just so I'm clear, you're saying that whatever the burden of proof is, someone saying that it higher up said that it wasn't available meets whatever the standard of proof is?
Well, I would say that the Commonwealth is entitled to proceed on proffer. And after the prosecutor said, I don't think that's available, my understanding is that's not available. Defense counsel said, I haven't looked into it. He said, I don't see why it wouldn't be, but I haven't looked into it. And even at the motion for reconsideration, I don't believe this issue ever came up again. So at that point, since the Commonwealth proceeded on proffer, the court took the prosecutor at face value based on his representation. There was no evidence that ankle monitoring was available, and defendant had the opportunity to say, get somebody in here.
But it's a Commonwealth's burden. So let's assume that a prima facie case is not sufficient. Would it still be your position that someone saying that it higher up said that home monitoring wasn't available would meet a higher burden of proof?
I think that that's within the trial court's discretion whether to accept that proffer. So, for example...
That wasn't my question. Let's assume that you need, under the Constitution, something more than a proffer.
Then yes, we would need actually hard evidence.
Okay,
the
because
reason...
you said earlier, if whatever standard we adopted, there was sufficient evidence on this record to support whatever that standard would be. But I think you're agreeing with me that if something more than a proffer was needed, the evidence regarding the availability of an alternative would not meet a higher burden.
I respectfully disagree, Your Honor. I believe it's cited in my brief. There's several lines of federal cases holding that even under the clear and convincing standard, under the Federal Bail Act, the state can proceed under proffer. You're not required to necessarily bring in live testimony, and that's left to the discretion of the presiding judge. So even under this heightened standard under the federal Constitution and the Federal Bail Act, you can proceed on proffer. You can meet your clear and convincing burden that way. So
just to follow up on Justice Donahue, but under the Constitution, you have to prove no condition or combination of conditions other than imprisonment will ensure the safety of the victim. If the ankle monitoring, I'm not sure what to do. You know, back when you're doing a preliminary hearing in this case, you don't expect to be here and arguing this. But if the ankle monitoring, in fact, would ensure the safety of the victim, then you've not met the constitutional standard if it's available to you and you don't use it. Again, in this case, it's messy.
it is very messy. I think that we are assuming that if ankle monitoring were available, it would somehow ensure the safety of this victim. That's not true, necessarily, right? He was arrested, and when he was released, he continued to harass her. So the firing the gun at her car, an ankle monitor doesn't prevent him from driving to a neighborhood and shooting at her window or hurting her or following through on any of these threats that he made. So respectfully, I disagree that that's somehow dispositive about whether he could have been put on ankle monitoring at all. Does that somehow prevent him from going and harming this woman? I don't think so. But that's kind of my opinion.
No further questions on this topic. Would you address the best evidence briefly in the screenshot versus the original text, which seems to be the principal lament of the defense?
Thank you, Your Honor. And if I may, I'll move on. There was one question you had asked about the remedy for the... So first of all, there are cases holding that this is really a moot issue. This could have been appealed under Rule 1610. Moreover, assuming that, defendant would have to make some kind of showing, and I'm not saying there's evidence, but some kind of argument for how this affected the outcome of the trial for us to get any further than this retroactive ruling that doesn't affect him. And there's really nothing in the record. There's an alleged cease and desist letter and some discussion of Facebook posts that he alleges he couldn't get despite the fact that he had an attorney whom he was corresponding with. We don't know about the letter existing. Assuming it existed, somehow his attorney couldn't get it. I mean, it's all quite thin, and it's based on a half dozen lines of testimony. Moreover, if you look at the timing of these things, the text messages occurred once they broke up. They stopped when he was jailed. They resumed when he got out. He changed his software on his computer after being visited by the police. A gun was fired into a car when his truck was sighted in the area. He changed the software. He installed like Tor and all these other sort of software on his computer to anonymize his internet browsing. He sent inculpatory text messages to a friend about...
What's the point?
Oh, the point is that you look at the overwhelming evidence of his guilt. It's not just that I couldn't get a cease and desist letter and that would somehow tank the Commonwealth's case.
All right.
So that's abstract, basically. The Superior Court also got it right that while the defendant has labeled his evidentiary claim a best evidence rule violation, it's really an authentication issue, and its circumstantial evidence established defendant's identity as the author of the messages. While there had been stray assertions that some of the messages were cut off, the crux of defendant's claims has long been that the metadata and other info not contained in screenshots could help identify the person who sent the messages. The contents of the writing were thus not at issue, and the defendant never raised a specific objection to these messages as being inauthentic or forged or faked. So the best evidence rule is not implicated. There is a stray assertion in the beginning. He said these could have been faked, but that was never pursued. There was never a specific objection. There was only this text message is cut off.
When I was preparing for the case, I tended to agree it wasn't a best evidence issue. But listening, I'm not as sure now, because let's just analogize it to a contract. And the best evidence of the contract is the document, the written contract. It's a written, not a verbal contract. If one of the sides brings in 2/3 of the contract and the other third's cut off, that does strike me as best evidence. The best evidence is the original contract. And I think that's the analogy that your opponent's trying to make, which is we didn't get to see the whole text message because we got a screenshot when the text message was absolutely available to you. It could have been downloaded and brought in.
I think that many of
That's completeness, isn't it? That's a completeness 106, right?
Is that the rule of completeness? Thank you. No, that's fine.
And I don't understand that to have been an objection raised, so I would argue waiver there. I would also note that this issue had come up before an appellate court in Massachusetts, which rejected this exact argument as a best evidence rule. And they said, well, this other doctrine of verbal completeness, that's not implicated. You didn't raise that, so we're not going to touch on that. Moreover, though, this is different from a contract in that contracts, as you know, any given provision or any words, those can be operative. Those aren't missing. You can have a skewed perspective of what the contract is. Here, if we're looking at who actually authored those text messages, it's not just the content of the text messages. There's the timing of them, right? There's I never got these before I broke up with the defendant. There's the fact that I didn't get them while the defendant was in jail. There's the fact that the defendant sent a text to a friend saying, hey, how do you spam a phone with so many messages? It just totally, and I'm going to censor this, messes it up.
Defense counsel indicated that the substance of the text messages, at least certain of them, actually pointed to a different individual having sent them based on the circumstances described in the text messages.
Yes, Your Honor. I believe that respectfully is an incomplete description of the facts. Some of those text messages not only purported to come from her other ex-boyfriend, but they actually purported to come from her daughter. Like her, and I don't remember if she was 4 to 6, but her little adolescent daughter saying, why you not let me see my daddy? So respectfully, it's obvious that these are coming from somebody purporting to come from other people. Like, it's totally implausible that she's getting text messages at this time from her ex-boyfriend as well as her little daughter, So it's not just that they purport to come from that person. Moreover, that person took the stand, and he said, I was with her a couple of times when she was receiving these. So there's contradictory evidence in the record that he could have sent those, because he was literally sitting right next to her when she received those. So, yes.
Because again, it's something that, this is why we have oral argument. Just forgetting that you prevailed at trial, that the jury bought your circumstantial evidence, just tell me again, why, be it the rule of completeness, as Justice Wecht was nice enough to point out to me, best evidence, whatever, why is it an error to not put in the totality of the message, regardless of who it's from or what was believed, and put in a screenshot which doesn't show it all? Just succinctly, why is that not error?
My understanding is that the victim was the one taking the screenshots. So she approached the police, told her she had a problem, and the police tried to resolve this informally. They called the defendant and said, give her back her stuff. They stopped by his house, said, hey, stop bothering this woman. All this happened before they actually arrested him. And then at some point along the way, they said, you better start taking screenshots of these and documenting these. So the screenshots originated from the victim, who was taking them and sort of holding on to them in case we need to bring charges against the defendant based on his continued harassing conduct. So while the police did have access to her phone, I think the defendant is suggesting that in preparation for possibly filing charges, we should have done a phone extraction and seen, what that would have produced, which is totally impractical.
And I don't know enough about the intricacies of criminal law discovery, so you'll forgive me. Did the defense ask for the totality of the text messages, and did the Commonwealth object to that?
Off the top of my head, Your Honor, I don't recollect. I can tell you that my understanding is that we turned over everything we had, which is the screenshots. I poured over the file. It's not like there's some kind of extraction report from her phone that's floating around that we didn't turn over.
Can I ask you, counsel, I know you want to argue the authentication aspect, but with respect to the best evidence argument, how would you relate to appellant's argument that the screenshot as presented can't come in as a duplicate because it's not accurately reflecting the information in question? That's at least a part of their argument as I understand it.
Yes, Your Honor. So my understanding throughout the entirety of this appeal has been that there's the metadata, there are hyperlinks, there's the information you would get from a phone extraction that's external to the actual message that she's seeing when she's looking at the phone, and that is somehow part of the writing that should have been provided. And we're, in the brief, we note that, if you look at the literature on, like e-discovery and electronic evidence, there's this distinction made between primary and secondary evidence, or, the primary data and the metadata. And it's not like metadata is some kind of, I'm trying to think of the appropriate metaphor here, but it's not like a smoking gun, because as experts, and I've cited this in the brief, have noted, you can easily fake metadata. As soon as you copy it from one place to another, it can be changed. It can be very easily altered, arguably more so than taking a simple screenshot. So there's that you have the primary and the secondary, and that, the actual writing that she received, that she was viewing on her phone, she took a screenshot. And that screenshot, under the rules of evidence, is the original, because it accurately reflects the writing that she was looking at, that she received. And then a printout of that would be also an original or a duplicate for purposes of the rule, if we're going to get into that. But the fact that there's no metadata, again, it's actually, the way I look at it, I don't know if this would be helpful, is that you receive a letter in the mail, you throw away the envelope is the metadata, right? It's got the stamp, it's got when it was processed at the post office, things like that. Things which, if you have them, could be probative, but that's not the writing. The writing is the letter. So I think that is a fair analogy here. I'm not sure if that was responsive entirely to your. I don't think so, Your Honor, except to say that, again, for the bail issue, you have to conclude that the standard is higher. The court abused its discretion based on what was before it at the time. And also that in order for this to be anything more than moot, that it had some kind of real impact on the trial, which I don't believe has been shown here.
Thank you very much.
Thank you so much.
have a brief in this case, Jim.
No, I don't either. Brian should bring him up.
Brian will get us a brief.
The next argument is Metal Green Inc. versus the City of Philadelphia, and Wickham Kramer III and Mary Kramer. Representing Metal Green Inc. is Mr. Stephen Pollock and Mr. Vincent Mancini. Representing the Kramers is Mr. Sean Whalen.
In this matter, the Commonwealth Court concluded that the Zoning Board of Adjustment of Philadelphia did not err in denying the application of Metal Green Inc. for a use variance for a blighted property on the grounds that Metal Green Inc. had failed to establish the requisite of the minimum variance test. We granted allowance of appeal to examine whether the Commonwealth Court correctly applied the minimum variance test under these circumstances and whether it used the appropriate standard of review. Mr. Pollock and Mr. Mancini, you're going to split argument. We took your case prior to lunch, so you didn't have to wait for an hour for us, and I'm going to politely insist that you don't repeat each other. We want a full argument, but not twice. Mr. Pollock, feel free.
I get to say good morning, because it's still the morning. Good morning, Mr. Chief Justice, Justices of the Supreme Court. May it please the Court, as the Chief has stated, we are going to split our argument. The Court granted us allowance of appeal on two issues, so I was going to address the error of law standard of, and on the minimum variance to afford relief, because I think what you find is everybody says it's the least minimum variance to afford relief, but if you look at the actual language in the Philadelphia Code says it's the minimum variance to afford relief. We're not looking for angels on a pin. We're trying to determine what can we do to use a property. So what we're saying is that there was an error of law that has led to a misapprehension of facts that got the Commonwealth Court to apply the old standard substantial evidence rule of review instead of finding, in this case, that perhaps we may have before this Court the first time where maybe there has been a capricious disregard of evidence. And Mr. Mancini will get into that. But as an overview, what we are saying is this Court said in Marshall that we believe the Commonwealth Court has misinterpreted not only binding precedent from this Supreme Court, such as the Marshall case itself, but also its own prior decisions in the long line of cases of Wagner and Vitti, where you're dealing with, and that's the real thing that's really at the heart of this matter. We're dealing with an existing, non-conforming, 90-year-old building that is vacant and has the actual designation through a separate court action that was going on simultaneously as an abandoned and blighted structure under the Abandoned and Blighted Property Conservatorship Act, as we all colloquially refer to it in the brief as Act 135. And so what we're saying is that in the past, this Court has gone there. This Court has looked at a case like Marshall, where there was a school building that was no longer in use by the Archdiocese of Philadelphia. They couldn't use it. It had been abandoned for 2 years. They came back with the opportunity to repurpose the building for senior citizen living, 63 units of senior citizen living. That was purely a use variance, because they needed to turn an existing non-conforming building that had built, I must confess, I think the building in Marshall's 100 years old. We're only a 90-year-old building, so we're a little younger at age, but still we believe the same things apply. And one of the things that we feel happened here is that, as this Court clearly stated in Marshall, finally, we have never required, I didn't use it, this Court used that term, never required demolition of a legally non-conforming structure to afford the opportunity to bring the property back into compliance with the zoning code. And what we're saying is that both the Commonwealth Court and the Zoning Board used this improper standard of requiring us to demolish this building. They were saying that our goal was, and we presented testimony through various experts. I mean, this is not somewhat maybe the typical Philadelphia zoning case that this court has seen in the past, but we had the architect testify, we had a land use planner testify, we had a traffic engineer testify, we also had one gentleman who wore the hats of being an MAI appraiser, a certified real estate broker, and in his spare time he was the vice president of a major commercial and industrial development corporation. And all of these witnesses go to and testify to that 18 is the number. What are we talking about? We've got an existing building beyond repair, and at the time I actually had Mr. Andrew Miller, who was the attorney representing Meadow Green in the Act 135 case, testify in front of the zoning board, and we put on those facts. And if you look at the findings of facts and conclusions of law of the zoning board, you won't find the words Act 135. You won't find the word that we're a non-conforming building. You will not find all the efforts that went into rehabbing this building to even get it to a point where it was still under the guidance of a conservatorship under the Act 135. And so you don't have any of that in the zoning board. There's a lot of other things that you won't find in the zoning board, and Mr. Mancini will get into it, because as we said, we believe there wasn't any finding of credibility determinations. There's not even in this case where they say, we find all of Pollock's witnesses to be incredible because they said that this could only be built, on a pie. They don't have any credibility findings like that. We had all the expert witnesses. There were no expert witnesses on the other side. It's the subjective opinions and impressions of neighbors. But what we're getting at here is that this court has found, with regard to hardship back in Hertzberg, because we feel this maybe has a flow of Hertzberg to Marshall to who knows what, depending on how this court views where we're coming from in this case, that in Hertzberg it was a dimensional variance, but the court said, hey, there are multiple factors that have to be applied. There's not one way to prove a hardship. And really—
Counsel, can I interrupt you for a moment? This isn't
Surely.
This isn't a hardship case. I mean, I understand, that none of the arguments that you're suggesting were made here. That's because this is being challenged based upon the failure to meet the minimum variance test. So, I understand what your argument is. Generally speaking, your client is doing really good things with this property that otherwise was a blighted property in this area, and so they should get a pass, except for the fact that there's this minimum variance test. And so I'd like you to address that. Are you suggesting that that doesn't apply here?
No, not at all. No, I know that's what the appellee claimed, that we're saying, hey, if you meet the hardship test, you've met everything.
Well, I've read your brief to essentially say pretty much the same thing.
I believe, and I want to I believe that what we were saying, maybe we didn't articulately say it well enough, is that there's sort of an intertwined factor that we thought at first, if you look at the thrust of this and you look at the history of the briefing and everything, there was a challenge to whether or not we had a hardship. That's why we put on a lot of different testimony. But I also say that the hardship dictates what you can then use the building for. It also dictates what is the minimum, not the least, but the minimum variance that I can do to revitalize this building, a building that has been found to be, in this particular case, an Act 135 building. But as I say, this court in Marshall said one of the things the Commonwealth Court didn't do in Marshall was recognize that the building was beyond repair, had been vacant, and so that you've recognized those factors before, even without the tag of an Act 135. But what I'm saying is that if you do not allow multiple factors to be considered, such as that if we were going to put 10 pounds of sugar in a 5-pound bag, if you look at the floor plan, at least 1/3 of the building on the first floor is dedicated to 19 parking spaces for 18 apartments. If we were going to cram every little bit of a variant, of a use into that building, we would have used that space, I believe, or we would have come in and said, we want to put apartments there. So the finding what,
The argument that's being made here is the opposite of what you just suggested. And let me just call your attention to something that I at least think is critical, because I don't see where any credibility determinations had to be made by the Commonwealth Court in order to reach its conclusion. As I understand the testimony, one of the members of the hearing board asked the architect if he considered fewer apartment units or condominiums than the 18 that was offered, and he said no. I didn't consider fewer. Now, doesn't that directly go to the minimum variance?
but I think what it goes to is a couple things, Justice Donahue. And one of them is that the condominium concept. Zoning never really deals with ownership. It just deals with the magnitude of use. So the question also, if you're asking for condominiums when you're going for apartments, there's usually a distinction in the mind of a calculation made that this neighborhood may not be ripe for condominium ownership, so I'm going to have an apartment building, as opposed to. So that could have been something. But I'll also get to that we had other witnesses, other than just the architect. Jack Coyle, who is the MIA appraiser, sort of real estate broker, when I asked him directly, and it's at 218 of R218A of the reproduced record. I asked him, we were going through the Mount Airy study, which was a 2025 study done by an independent agency that had a chart, and the chart's included in our record at 614, 615, and 616 of the record. What are the sizes of the units that are there? The lower level units are about 750, the upper level 800. This is Coyle. I think they are right in the wheelhouse of the market, I ask. So if you were right in the wheelhouse with the 18, that is the number, that is the minimum you can give to afford relief for this. Coyle, this is what I believe. Yes, so is it my requirement, especially where you don't require me to demolish any building, to try and meet a vague standard that's a conversion to a less dense use with fewer units was not possible, where my architect said, could you build this according to what's permitted in this district? And he said, no, you're going to have to tear this building down. Yes.
It strikes me that your argument's respectfully relatively simple. In the last page of the Commonwealth Court's opinion somewhat capsulizes it. Isn't your argument that you put forth to build 18 units in this building, and that it's abusive of discretion to say, well, perhaps 17 or 16 would suffice, and to get into cutting with that kind of sharp knife, that kind of minutia?
That is basically where we're coming from, but we also say that they're asking us, is the burden on us to prove what the minimum variance is necessary to relieve, especially a building that is under the jurisdiction of a conservatorship, under the jurisdiction of a court, but is also, besides that, abandoned and blighted, a nuisance in this neighborhood, because, and we're trying to live with this building.
I might say the same thing. I might be saying the same thing again, but again, I don't think it's, if I'm not missing something, that hard from your viewpoint. You're, in good faith, your designers and your experts looking at how much square footage should be in a unit and what the rent would be into this property, this locale, chose 18. And I think what you're saying is when I think the neighbor testified, well, I might talk to them if it was 17 or 16, that it's abusive of discretion to do that.
If anything, the neighbors, if you look at the neighbors' testimony, Mr. Chief Justice, they say we've had several developers come and offer different things, and they've always gone away. Because I don't think this, if you look at, what went on, one of the neighbors testified that she had an offer, who actually testified in the case, Colleen Floyd, testified that she had actually put a bid on the property, had done a phase 1 study on it, and backed away from the agreement of sale. So, but we're also saying that there's been a line of cases that have recognized it's Wagner Vitti, it's Hertzberg, and in Marshall you apply the multi-factor test there, that unless you relax the standards and have a multi-factor approach, just as you've done that to unique hardship, we're saying that if you don't do it for all the other factors of the variance, especially when you're faced with an existing building where it's non-conforming, that I'm not asking to expand, raise the height. All I'm trying to do is do what the legislature of Pennsylvania has said, let's rehabilitate, let's not demolish. And we're saying that by saying even the standard that they suggested, when you suggest can't you go with 18, I think our testimony established that the only way to do that would be to demolish some of the building, and that you're not requiring us, this court has never required anybody to demolish the building to come into compliance. So that would be where we are with regard to that. I'm going to allow Mr. Mancini to take up the mantle with regard to what we believe are deficiencies in the findings of facts and conclusions of law of the board, but I will just raise this one thing and put it in your mind, that when it came to Jack Coyle, the Commonwealth Court, in its recitation of facts, says that on redirect, Pollock does get at that line where he says it's 18. When the opinion, Judge Robson writes his determination and evaluates it under the law, let's apply the facts to the law and see where we're going, he avoids totally any reference to what Mr. Coyle says, where Coyle definitively says 18 is the number given all his experience and everything like that. So that's our point, is that we feel, as Chief Justice has said, we think it rises to more than an abuse of discretion. It was really an error of law in that they applied the wrong standard, that the only way to come into compliance would have been demolition. They're asking us to prove a negative when we're proving a positive. This is our 18.
Good job. Thank you. Mr. Mancini? No piling on.
Thank you, Chief Justice.
Chief Justice Castile Lang.
It's always a pleasure to follow Steve.
No piling on? Oh, yeah. Castile. I'm sorry, go right ahead.
Thank you. If it may please the court, I have the enviable task of addressing the capricious disregard of evidence rule. I'm fully cognizant of Wintermeyer. I'm fully cognizant of the difficulty of applying that concept. I sympathized with the nuances and drafting and insight of that case. It was an eye-opening case for me, and I've read a lot of them. But I would also submit to the court that the lower court's decision, I think it's susceptible to ignoring a capricious disregard standard, but also that I think that the lower court's decision can be, is an error because it failed to reverse the zoning hearing board because its findings, its conclusion of law was really not supported by competent evidence of record. And that case is actually reflected in the appeal of Jones, which is cited in the brief. But I'll address that one a little later, if with the court's permission. The capricious disregard of evidence, it's a gray area, very fine lines between substantial evidence of record and deference to the quasi-judicial hearing bodies, whether it's administrative or the zoning hearing board. And when you go into the area of capricious disregard of really significant evidence of record. And what does that mean? I think the court in Wintermeyer did a superb job of laying it out. It's basically when you have a substantial findings and what have you, and there is and where it is clear beyond doubt, and it's not a simple burden, its conclusions were based upon capricious disregard of other evidence. And then the court indicated that there are certain indicia that you look for, failure to make credibility findings, jumping from stated facts or summaries of testimony to a conclusion and never connecting the dots, so to speak. How do you get there? What was the reasoning? And the Commonwealth Court has criticized in a number of cases, have criticized the failure of zoning hearing boards to do that, but unfortunately, they either waived the argument of capricious disregard, or I think it was mostly waiver, and that was also in Talafiero and another case that was mentioned but not reported. But the problem with capricious disregard is basically finding a case that fits this category, because the test is general. Disregard of apparently reliable and persuasive evidence that a reasonable mind could not ignore. Well, do we have that here? I would submit to your honors that we do. It's one of the few cases I've read in 40 years that I think is on point. Why? This case involves not just testimony, but objective facts, uncontested facts, and I will get into that. And then the testimony comes in from 4 highly reputable experts, and I know of all 4, and these are really people at the top of their fields. Then, on top of that, the experts are not rebutted, and unlike in Wintermeyer, the facts that they relied on their testimony and opinions was unrebutted. In Wintermeyer, I think Justice Saylor made an astute point and correct conclusion that the medical expert there basically said that, well, let me start over on that. The claimant before the Workmen's Compensation Appeal Board, or Workmen's Comp judge, and claimed that she had carpal tunnel syndrome because she worked for 2 employers, including the current one, that required her to spend 75% of her time at a computer, and the repetitive motions with the keys and whatnot led to the carpal tunnel syndrome. The doctor that testified said, yeah, that's assuming that. It is absolutely correct, it is connected, etc. There was no expert rebuttal on that case.
Mr. Mancini, this
Yes,
is
sir.
an unusual issue for us to take. It's generally the Superior Court's role to do the kind of factual review you're suggesting. We understand the standard, and we understand what you're saying, and at least one, if not more than us, will read every word in this record and make that assessment on your client's behalf. So unless there's something else,
Sure.
I think we understand the legal principles involved.
My point is simply, Your Honor, that it's not just, it's a host of, it's an avalanche of undisputed facts. The big building is the biggest elephant in the room. You know, the size of the apartments are clearly facts that were taken from the 2025 study, which was not, it wasn't prepared by us, it was prepared by the city, and all that stuff. And all I'm saying is, on top of that, you have 4 expert witnesses that takes those objective facts, uncontested, and their testimony just flows logically from those facts.
It shocks the conscience.
Excuse me, sir?
It shocks the conscience.
I don't know about shocking the conscience, but it's kind of obvious what was happening.
I'm anxious to hear from Mr. Whalen,
but-
so if you could finish up, I'd
All
appreciate
right.
it.
And on top of that, then you have the fact that there's case law that supports their position as well, and it fits into the case law of Marshall and its progeny, and which Marshall, by the way, dealt with, you know, a potentially deteriorating building. This case, the Act 135 determination is way beyond that. You know, roof is falling in and whatever. So I'm saying that when you have almost like a capricious disregard of the law as well, because Marshall was never mentioned in the zoning hearing board decision. Mr. Pollack argued it. It was there. The burdens of proof was there, not addressed. Secondly, the testimony
Well,
given.
and as I think Justice Donahue said to you, though, Marshall is an undue hardship case. And again, as I said in the last case argued, this gets messy because if you
does get
read the zoning board of adjustment's opinion, it spends 9/10 of its time on due hardship, on unnecessary hardship. but
I'm just saying that the
We're here on this.
testimony on the minimum variance was given by both Mr. Quill, and there is clear testimony that 18 was the minimum. They started out at 21, it dropped down to 18. It was the same, the architect said, look,
Is that in the record?
yes,
That
sir.
they started 20?
I can give you the page number.
No, I don't need it. We'll find it.
Okay. Secondly, the architect said, look, if you want me to put these size units in here, you've got to have a minimum of 18, or you're going to have a portion of the building not used, and we got to tear it down, or whatever. Thirdly, Mr. Ritter testified that, look, these are the size units that are in the area, uncontested, and also that the minimum you need from a land use planner, which I don't think is as critical as the MIA appraiser, Jack Coyle, but he indicated clearly, again, in the record, and it was on cross-examination by Mr. Whalen, yes, 18 is the minimum. Now, on top of that, there's a practical situation on the minimum. There's two ways we could have put 10 pounds of sugar in this bag, or in a 5-pound bag. One, we could have made those units smaller and in the same area and still probably get 40% more units. Two, we could have used every square inch of that building, first floor and second floor, for units. We did not. Meadow Green proposed the first floor for 19 parking spaces. You don't rent, and they're not rented, they're part of the rental rate with the unit. There is no sticking 10 pounds of sugar in a 5-pound bag here. It was a very delicately done effort, and keep in mind the character of the community came up. Well, there's 7 homes right after another going towards Carpenter Street on Quincy. The first two next to us, 6 have been converted to 6 rental units each. And then it just progressively went down between 4 and 6, or between 4 and 5 down the rest of the block. Again, there was no intent, no evidence to show that that this was not the minimum variance. Right. Secondly, Jones, if this court is disinclined to go with a capricious disregard, I think NRA appeal of Jones should be looked at very closely, because that case basically said, look, where you have objective testimony and unrebutted, and this is an application for a variance which was denied, and the Commonwealth Court reversed, and there was just objective factual testimony that wasn't contested, augmented by a traffic expert saying there's no problems with the traffic, despite all of the neighbors' objections. Then they said that there wasn't substantial evidence of record to support the conclusion that it was a detriment to the public health, safety, and welfare. Thank you.
Thank you very much. Mr. Whalen?
Yes, thank you very much. May it please the court, Sean Whalen from Vintage Law, here on behalf of Apple's Wickham Kramer III and Mary Kramer. They are husband and wife. I know there was.
Raise the microphone, please.
Is that better? Would you like me to repeat?
No.
And I would be remiss, my colleague David Dean is here as well, just make sure you can get on the record since he did a lot of this work. Meadow Green Council just raised a lot of points, so I'm going to try to succinctly tie this together since I know everyone's heard it and read the book. What you've heard is Meadow Green, like any developer, I've handled probably 100 or more cases, so has Mr. Pollack, wishes the ZBA ruled differently. That's really all this is. Did Meadow Green bangs the drum over and over again that it presented substantial evidence in its favor? Absolutely it did. I don't think our briefing ever says that it didn't, and I don't think that there was ever a conclusion by any entity, organization, or court below you that says that it didn't. Unfortunately, that doesn't matter. Because the zoning board decided the way it decided, this court's appellate review is based on whether there was substantial evidence in the record for the zoning board to decide as it will, and I'll get to the framework. Secondly, Meadow Green says a lot, Act 135. We never argue Act 135 because there's nothing to argue. This is not a zoning-related act. There was a court order. There's no disputing it. We didn't dispute it, that it was dilapidated. We knew it was blighted and dilapidated. In fact, there had been community upswell to try to get the, this order going, so somebody else did it and beat the community to it. That Act 135 is a very important factor to hardship. And should there be a lesser standard applied to hardship? Yes, we agree. We've conceded hardship. We did it at the zoning board. We haven't done it at any point in time. The lesser standard is appropriate here. And I would argue, barring an extreme situation, I'll use Philadelphia as an example since that's where this is coming from, any 100-year-old plus existing commercial or industrial warehouse that is now in a predominantly residential neighborhood, and I will suggest to the court that there's a lot of them, has a hardship. It's a massive building. It's a huge undertaking to demo. Nobody has said that they have to demo it. Meadow Green kept imposing that on themselves, saying throughout the record, well, you're requiring us to demolish the building. No one argued that. Next, they argue that they need to be able to productively reuse the property. This is a very excellent point, because they do. Property rights state that we live in this Commonwealth. But again, Act 135 just says this property needs to be put back in use. It does not usurp the decision-making authority or the discretion of the zoning board. It does not circumvent any underlying zoning requirements. You have to still go through. They are separate, siloed considerations that may overlap, and there may be points at which, like in hardship, you say, okay, well, you want a zoning variance. That means Act 135 is applicable. It's definitely a factor, and a strong one. And so what they're really asking you for is saying that this lesser standard, as pointed out by Justice Donahue, this lesser standard that this court has a long history of with regard to hardship should be extended to the court's review and I guess the zoning board's review of this least minimum variance standard.
No, I think that's the key. And I was trying to listen politely to let you articulate your course, but you latched onto it. They present a question of law, the first question that was done, which is that the zoning hearing board and you just made a mistake of law when you said least minimum variance. Their argument is that the test is minimum variance and not least minimum variance, and that there's a substantial difference when you put the adjective least in front of the word minimum. And I looked at finding of fact 9 in the zoning hearing board's decision, Board of Adjustment. Are they the same thing?
There's a ZBA, Zoning Board of Adjustment, in Philadelphia and in Pittsburgh, because they are entitled as first-class cities to have their own board. Bless you.
The entity here used the term, the requested variance represents the least minimum variance. You just used that too. Is that a correct statement of the law, or is the statement of law minimum variance, and do they matter? Does that matter?
Sorry, I interrupted you. I believe it's a distinction without a difference, but there is a distinction there. Colloquially, and I believe actually from the courts, and I don't remember which case standing here now, the courts have sort of turned that phrase from minimum relief required to minimum variance to afford relief to least minimum variance. And again, it's just a colloquialization of the same idea in that it's just easier to say and it's easier to write, and you can see how this sort of got shortened over time. And I would say that this is all part of that same framework, and including the arbitrary and capricious standard. So here, this court has a very long history of well-established case law, and again, zoning law, cases from 100 years ago are still good. Other areas of law, that's not true, but I talk to other colleagues and they say, well, this is from 1952. I'm like, nope, still good law. So it's well-established framework that the zoning board is delegated the power to police zoning and have the authority to determine whether or not the evidence satisfies the criteria for a variance. We can start with Marshall and go all the way back. It's also clear that the applicant bears the burden to satisfy all variance requirements. There's no burden shifting in zoning. There may be in other areas of law. Again, that might be an issue that this court wants to entertain with regard to any one of its 3 tests. The fundamental basis of this whole argument is Marshall, which this court set down just 7 years ago, has a 3-pronged test. One is for hardship, again, off the table. That's kind of got its own body of law. 2 is that there's no detrimental impact to the public. That's actually not addressed here, but the zoning board did find that there was a detrimental impact to the public, or rather they found it in the negative, that Meadow Green did not prove that there was no detrimental impact to the public. And 3, this minimum variance to afford
It's hard
relief.
to see how there can be, and I'd have to reread the zoning hearing board, but it's hard to see how there can be a detrimental to the public. The exterior of the building is not changing at all. The lawns and gardens are not changing at all. You're not adding to the parking since they have interior parking. The casual observer might not even know anything's going on. So I don't see how the public is adversely. In fact, I think that the fair inference would be the public's being benefited by a blighted building coming off the street and replaced with an occupied building.
I think actually, Chief Justice, that's a great point, because that is really what I think is the crux of this case. That's exactly the viewpoint that Meadow Green would have you believe. This building's being fixed up, you're never going to notice any difference. Well, this gets to what Marshall also said was the local zoning board or zoning hearing board has the authority, the discretion, based on its local expertise, information, context, all of that, to make these discretionary determinations. So, yes, I don't know.
We're not potted plants. I mean, they're not, they have great discretion, they can't abuse it. That's the...
Absolutely, absolutely they can.
And counsel, in that regard, what determination did they make to the contrary? I mean, the Chief Justice just asked you about the restoration of the building, and I guess you're suggesting that the ZBA, well, obviously they wanted something more of a showing. I guess what did the ZBA have in front of it to indicate this was not an appropriate variance?
So the ZBA had a lot of facts. First of all, obviously you jumped right to my next point. The ZBA is free to object, accept, adopt in part or whole any testimony rebutted or unrebutted by a lay witness or an expert. And that's not reversible error for it to do so, but it does need to justify it. So here, there was, you have, I actually wrote it down, I think 53 findings of fact, 11 conclusions of law, a 254-page transcript, and over a 300-page record. So anything that may or may not have been found, and there's certainly a lot of truncation, I'm not sure if I just made up that word, in the findings of fact themselves. However, even just a simple example that I came up with while I was sitting here, the Meadow Green purchased this property sight unseen with no diligence from sheriff's sale for approximately $90,000. It was just under $100,000. I wouldn't represent, I remember the exact number. That's a fundamental factor when, the counsel for Meadow Green at the hearing is saying and having all of its witnesses say, oh, well, this is prohibitively expensive, we have to do this. Well, they only bought it for $90,000. So that's a key point that the zoning board may or may not have in their head. And again, I can't jump into their shoes, and I can't substitute my judgment for theirs any more than this court can. But the evidence is rife with examples also from the neighbors, and I think this is actually a great point that Mr. Mancini raised with regard to the Jones case. So the Jones case is actually very easily distinguished here, because that case, while almost every case in zoning law reflects a purposeful reaffirmation of the decision of the zoning board underlying in that case. Almost every case we cite, almost every case Meadow
Mr.
Green
Whalen,
cites.
let me stop, because we're almost done. And Justice Wecht asked you, and I asked you, how is the neighborhood adversely impacted? Succinctly to the point.
Very succinctly, the evidence in the record will reflect this is traditionally a single-family home neighborhood or larger single-family homes that have been subdivided into a smaller number of units. Again, the record will also show behind this block is a block with large-scale apartments. Those are not the same neighborhood, and what you have a lot of testimony from is that 19 units is simply too much. Now, would...
Too much for what? I don't-
For the zoning board. Again, in its discretion,
It's too much, what, too many more neighbors?
too much density in order to meet that, I'm going to use again, least minimum variance test.
And why wasn't it too much density to have those adjoining residents subdivided for renters?
I'm sorry,
Why wasn't it also too much density to have the neighboring homes subdivided for renters?
so the record will reflect that most of those subdivision for renters in the 4 to 6 unit range are illegal.
Or illegal?
Yeah. They were not done, illegal meaning not that they are inappropriate or dangerous conditions.
They didn't get permission.
But they didn't go through the zoning permits. They've been there for decades. There's testimony.
Some of those the same neighbors that are objecting to Meadow Green's project?
I don't know, and certainly could be on the, and it's a fair point. But here, again, sort of to differentiate this from Marshall, one of the key points that they set forth was there was overwhelming support from the neighborhood. In fact, there was one objector who sort of had easily wiped aside objections. In this case, you had a unanimous decision from the local, the registered neighborhood organization against the property. And you had...
But based upon, and I certainly don't want to badger you, and we're almost done, based upon your logic, they do want this building torn down because they would object to 10 units in there, 8 units in there, 12 units in there. They don't want an apartment building on their single-family street, which is not necessarily unreasonable, but you are stuck with this big building there that's 100 years old.
Actually, quite to the contrary. There's no record of the neighbors wanting it torn down. My immediate neighbors...
What do they
They'd rather
want?
have a blighted old building?
Yeah, what do they want?
No, so they actually said at the hearing that they would accept up to 6. I'm sure this, there was a bit of a negotiation going on at the hearing between the developer and the neighbors. And would they have accepted 10 or 12? Yes, they would have. I would represent now to this court that they would have represented 10 or 12.
Is your argument that ZBAs should give a veto power to some neighborhood group? Is that
No,
your argument?
sorry if I cut you off. No, absolutely not. But again, is it a factor to be considered? On the flip side, it's more indicative, I believe. If there's overwhelming support, why would a zoning board get in the way of something that has overwhelming support of the people?
Presumably, if a neighborhood group gave overwhelming support, that also would not be entitled to rubber stamp from a ZBA. Doesn't a ZBA have other obligations other than to listen to loud neighbors shouting yes or shouting no?
Absolutely. And to your point, yes, it has an obligation to listen to both. Neither should be one should not be rubber stamped and one should not be automatically agreed to define it. The real issue is, without this test and without the ZBA having some check other than hardship, Meadow Green or anyone else could come in and could immediately say, I don't want 18 units, I want 30. I want 50. The zoning board has to have some ability to...
That's my question again to you. Is it sufficient evidence of record in this case that the architect was asked whether or not he considered fewer than 18 apartment units and he said no? Is that sufficient?
I believe...
All the other information that you described, like Phila sending in the community and things of that nature. If there is evidence of record to support what the zoning hearing board did that the Commonwealth affirmed, then it seems
Yes, I believe that that's the case, and I would suggest that that would be a key point of information and testimony that Your Honor just pointed to. However, I do think that there's other pieces of information. So it's not like the zoning board only had one, but that is obviously a key and vital piece of information that the Commonwealth Court glommed onto.
Single-family dwelling unit zone district. I mean, that's what we're talking about. So we're going from, one family to two family residences to all of a sudden there's 18 units.
Correct. And again, the neighbors never asked for it to be demolished. They've never asked for not having even apartments there. They've suggested that they would prefer condos. Most neighbors would, but that they would prefer more units and simply that 18 was too many, and that was what the zoning board agreed to. Not that it had to be 0 or 1 or anything else, but just that 18 was too many.
Thank you very much.
Thank you.
Thank PCN for lighting the courtroom today. Appreciate it, and we'll stand in recess.